Can I just say something about Andrea?
Happy Friday night, everybody. It's the weekend. Welcome to the weekend. We made it through the preliminary hearing. We wrapped today. Well, at least as far as the evidence goes. I'm sure many of you saw, like, as soon as court broke, new filing from Erica Kirk and Charlie Kirk's family as well joined in that filing, and they are requesting speedy decision on the preliminary hearing, basically asking Judge Graff to issue his decision on the September 1st hearing. So we already talked about that at the end of the live stream. He might do it anyway, might be inclined. We'll just have to see. Definitely expecting a written decision from him, like we've seen with most of the rulings so far. The abundance of caution kind of favors doing that. But yeah, still can't really say the preliminary hearings are a wrap when it's going to be another 2 months before we have a probable cause determination. So I've got that victim representative request. It's up on the Substack now, if you want to go check that out. Still haven't seen these memos that the defense and the state filed, supposedly, over their positions on the public access. I'm really interested in seeing those, but I'm starting to suspect we're not going to. And I'm remembering the very end of the hearing on Wednesday, when the judge suggested perhaps you would file a memo. He calls it a bench memorandum. The word came up between them, like a bench memorandum. I didn't really think anything about it at the time, but now I kind of am, because I'm wondering if they're treating it as not part of the file. When a judge has a clerk, it's common for the clerk to write the judge little bench memos. And when they do that, it's not typically going to be part of the court file, nor is it typically going to be part of the court record, because it's considered part of the judge's notes. And so as part of the notes pertaining to his deliberative processes, typically those are often not covered under public records rules. Now, of course, Utah's got very, very broad and very specific rules for public, what constitutes a public document, and applies that to court records and everything. So I haven't gone and poured through all of the nuances of that rule. But I remember it. I remember that bench memo. I wonder if that means we're not going to see that. I wonder if that means he's going to treat like memos from the attorneys as deliberative aids, not have to make them public. Because I really did want to see, is Mr. McBride hold Mr. Novak's feet to the fire on this case law? Is Mr. Novak acknowledging? Is he backpedaling from his position? Really did want to see, but at least so far hasn't landed, so I'll continue to keep my eye on it. But otherwise, today was our wrap for the evidence, at least. 5 days. 5 days. It's been a week, guys, hasn't it? Fortunately, I mean, there's really, honestly, not that much to recap, right? Because so much of today was more of the same. So instead, we're going to get to turn to the fun stuff. Of course, going to do the recap, but really not expecting it to take very long as the chat cackles. Andrea's not going to take long. See you in 3 hours. But no, I really am looking forward to taking a look at the information, the very specific charges, and then taking the opportunity to review what we saw over the course of the week, just the various pieces of evidence that the state's presented. And also, because we're at a probable cause stage right now, of course, all this evidence is looked at in the light most favorable to the state. So it's what they call a prima facie case, legally speaking. If you assume it's right, is it enough to get you over the hurdle? But it's going to be a very different situation when they get to trial because of the higher standard of proof. And so I might have a little chance to talk through some of the options, some of the strategies, the approaches, openings the defense might have to try to explore ways that they can try to make it weaker. So we'll talk about all that, and that's going to be fun. But let's get through today, right? Let's get through today because we started off with the inadvertent disclosure of the note yesterday, and that was from Mr. Novak. Reminds the court. We start with that. He calls it a colloquy with the court, which is, yes, that's a very formal. The cameras in the court, they engage in a colloquy. That is the very proper way to put it. Not like I call it the struggle session, but everybody's been on notice about the rules for the cameras, and we've spent all these hours addressing what can be published. And it's funny because I was going back through all of my notes for the whole week this afternoon, and I'll tell you, I'll just show you. I'll give you a visual. This is my notes for the week. Okay, but I was going back through everything, and what really just astounded me was how much of that volume is taken up by these arguments about what we do and don't get to see. I mean, talk about inefficient. You just had a consistent principle that was a reason that you stuck with. Wouldn't have to spend all this time on it. But we have indeed spent many hours going over that. And this very specific one, the court ordered it was not to be published on the camera, but it was. So from the defense's standpoint, it's the media and the state that control the access to the exhibit. And the court had balanced the rights in favor of not publishing. And of course, they're going to say it was a brief mistake and it was corrected after they realized it. But the problem, of course, is it's already out there. And in fact, he could frame it. He could print it out and sell it if he wanted to. Of course, he won't. But bottom line being, yeah, the damage is done. It's out there. And so that has violated Tyler Robinson's right to a fair trial. And he brings it up because the court needs to know that the court's order was violated. That was awkward. So the judge first wants to know what remedy he's asking for. Reminds them he's aware. He knows what happened. He takes it very seriously. And so Mr. Novak says they want to think about it. They're not sure. They want to think about what they think the appropriate remedy is. And so they want to do that and then suggest something before the next hearing. And the judge says, well, no, because if it's a problem, I want you to deal with it right now. We need to deal with it immediately. And so we asked them to confer between you, amongst yourselves, because he's concerned and he was thinking about this last night and it was weighing on him. And so he wants to deal with it. So Mr. Novak asks to take a break so that they could discuss. And the judge says, well, let's hear from the state and the media. So Mr. McBride speaks for the state. His position is that everybody's doing their best here and gives the background that during the examination of the witness, the exhibit was exhibit that had been previously published was being displayed on the screen, and then the exhibit at issue was put up, and the camera did not pan away. So he says he received the video, and according to him, the camera captured the image for about 2 seconds and then panned away. And the court took it off the screen, and he told the paralegal to take it down. Everybody, according to him, made quick and appropriate efforts to mitigate the situation. He also says that the defense didn't object when he said he was going to do. When he said what he was going to do. And I kind of remember that because I do remember him saying, you know, if we look at these side by side, but he didn't say, you know, I'm going to publish these side by side. So I did find this a little blame shifty, you know, a little trying to put it on the defense as if, you know, you knew what I was going to do, but you didn't say that part explicitly. They knew you were going to compare the images, but they didn't know that you were going to put it up on the screen, the public screen, where the camera was potentially going to pick it up. As far as the damage, however, he says this exhibit was read into the record. It's in the information. It's cumulative of other exhibits that were published in court. He says we're going to be dealing, you know, with lots of publicity, and there's going to be bumps in the road, so to speak. So bottom line, state thinks unfortunate mistake, but it was handled appropriately. No harm, no foul. The judge says, I want to weigh this. He says he finds the representations to be accurate. His recollection is that he saw it and asked for it to be taken down. And he says he knows because he has a copy of the live stream on his desk for that purpose. So the judge is watching the live stream with us. I wonder if he flips through his favorite commentators. No, I know he doesn't. But so he says he wants a good record for whatever happens next, because we need to make sure that whatever remedy is proportionate. Mr. McBride also then explained that part of the problem was that he wasn't able to see the screen from his position questioning the witness. Remember, Judge made him turn off the screen at the podium, and you got to be at the podium to ask the questions. So this whole thing has just gotten very, very convoluted, and it's part of the cause of this problem. The media attorney then spoke up. He says, our understanding of what happened is consistent. There were the two exhibits at issue that were juxtaposed for probative reasons. The first one was already published to the courtroom, but not to the cameras. And then later in the day, the second one that was introduced, that was allowed to be published on the cameras as well. The second one was the burnt one. The first one was the one from the interview, that was shown to Lance during the interview, the intact note. The lawyer says sometimes mistakes happened, and to his credit, her credit, the camera person panned away from the screen. The screen is specifically there for the camera. The judge has specifically adjusted it for the camera, so the camera is not doing anything wrong by pointing the camera at the screen that's there for it. But realized, recognized this was not how things were supposed to be, panned away. Understood that this, previous exhibit that was not supposed to be shown was put on the screen. And so camera pans away, court realized at the same time, not trying to minimize the significance because, now somebody can screenshot it or whatever. But bottom line, we're all trying to work together to do it right. He agrees that several lines of the exhibit, it's already in the information, and in fact, the full text is in a search warrant that was filed on September 17th, held for 6 months as the warrants often are, and then around March 16th or 17th, it was released in full. And page 7 of that search warrant contains the full text. Sir, thank you. Thank you for noticing the search warrant, bringing that in, because that is an important part of what is already public record. It may not be widely disseminated, but it is still public. It's out there. So there's nothing really wrong with sharing something that is already out there. Now he clarifies, I'm not saying that just because it's public that we'll show it anyway, even, regardless of what the court says about it. He's just for purposes of the court's comfort. You said you were up late last night worried about this. This is on your conscience, whatever. Just want you to know that it's already out there, Judge. So you can kind of chill. He agrees that the media has an obligation to make sure that mistakes aren't made. And while he thinks the camera person didn't violate the court's order, nevertheless, because the camera was pointed at the screen when it happened, when the exhibit was put up, it's what happened. So the judge pauses. He says, I want to review this and look at the whole thing again, get his record. Mr. Novak then steps up to say, we're ready to talk about our request for the remedy, but we can wait if you want. But he also, of course, wants to respond to the previous comments, and he says, the permanence of the violation is a different issue from like how long the camera was pointed at it, because doesn't matter, now it's out there. And he also wants to say this isn't the first time it's happened. There was the earlier incident when the camera depicted the forbidden images in the courtroom. That's when they were in the different position and they were catching the papers and computer screens on the camera because they just couldn't couldn't not pan in and stuff. So now Judge moved the camera in response to that. And he points that out as well. The court had to take measures to deal with the cameras. So we took what was supposed to be a 5-minute recess, ended up being, more like a half-hour one. And then when we come back, the judge makes his findings. He makes his findings. Now we're going to talk about this a little bit. So he makes his findings. So here's what he saw. Exhibit 16 and Exhibit 24. They're displayed on all of the monitors, including the public monitor, for a total of 3.5 seconds. He says the camera operator redirected before anybody called it out. And then 16 seconds later, the court paused. And Mr. McBride said, let's take that down. Finds that the full text of this document was previously available from the search warrant. Finds that 15 of the words from the document were in the information. The full note had been read into the record in this hearing already. The Exhibit 16 was not shown in its entirety on the screen. Like what it captured was not the entirety of the exhibit. And when that was admitted into evidence, it was published to the courtroom, but just not to the camera. These are his findings. What's kind of missing from anything in these findings that really supports a sanction at all? A finding of willfulness. A finding of willfulness. We just went through a long contempt hearing over the prosecutor's statements and their comments to the press. And this was like one of the key issues about whether there was a problem here. It's that because for contempt to be punishable by the court, it has to be a willful violation. If you accidentally violate the court's order, if you you sleepwalk break it, for example, non-volitional, something inadvertent, you're talking to your own defense, you're talking to your own team, and you don't realize that, somebody is listening in behind the cracked door that like you didn't close all the way, and then they run out and publish it or something like that, It's not sanctionable. It needs to be a willful violation. And he didn't find anything remotely approaching willfulness. His findings are this is an accident that happened. So I really couldn't help but notice that. I went back and read through these things. How does this warrant a sanction? Little bit of a difference from the situation with the prosecutors. Remember that whole argument about the civil versus the criminal contempt? In the case with the prosecutors, it was a civil contempt because it happened outside the presence of the court. And they're not trying to punish them for it. They're just trying to get a remedy for the future, you know, just trying to remediate the harm. This is different. This happened in the presence of the court. So this can be a summary, you know, punishment type of sanction. But it's still got to be willful. Where was that? Where was that in all this? So after his findings, we go back to more argument. We hear from Mr. Novak again. The remedy, they of course are renewing their request to exclude electronic media coverage from all future proceedings, the cameras, the still, and the audio. As if that's proportionate to a video 3-second thing. Oh, yank the audio too, like. But we knew it was going to be a maximalist ask. And he argues it's the second time that's a violation. And Judge, I'm a baseball fan. I don't think you need to wait for a third strike. I don't think you need to wait for a third strike. If it were deliberate, I would totally agree. I would totally agree. If this was another one of those situations where the decorum order is plainly in place and it says real specifically, here's what you can look at, what you can't look at, etc., like Court TV did over there in Moscow, Idaho, and just wouldn't abide by it. Got a crystal clear order. Don't zoom in on Koberger's face. Don't just like sit there and stare at him and like try to lip read him and stuff. And they just couldn't not do that. And so multiple times, over and over. And that's why the cameras got the Court TV cameras anyway, got booted. Judge still let us have the court's own system, the remote court camera system. But Court TV got booted because they just couldn't, like repeatedly, just couldn't do it. I didn't see that here. I didn't see anything like that. So it seems a little, the first time when they were staring at the screen, I don't have a problem with that. Like, yeah, the judge said specifically, he's got to order. Don't show the screen. They're showing the screen. We have a problem. But I just failed to see how the camera could have avoided this. And barring some kind of, indication that this was intentional on the part of the state, that they did it on purpose, I just don't think a sanction is justified. It's clearly an accident. And it's in part complicated by all of these other complications that the court has kind of created by virtue of just being so nervous Nelly about what gets shown on camera. But he thinks we don't have to wait for the third strike. So that's what they want. No more cameras, no audio, nothing for any future hearings. But in the alternative, just in the alternative, in case that's too much. We don't think this alternative is nearly adequate enough, of course. But alternatively, they thought just reverse the electronic media coverage order for today. Just yank the cameras for today. That's all. And also, by the way, proactively, before anybody even asks, let's just not have cameras for the September 1st, too. I found this so strange because all we got going on today is your witness. Your witness. Why are you even calling this witness? Do you not expect it to really help your client? I don't know. I think if that was like going to be the cost of just getting a foot in the door of getting the cameras yeeted, that would be acceptable to them. But it seemed very strange, like you're punishing yourself, kind of, unless your defense is, I don't know, bullshit. And so it doesn't matter if we don't see it. So he acknowledges that, of course, there isn't a actual request yet for anybody to do the electronic coverage for September the 1st, but there will be. Yeah, there will. We all know there will be. And, and according to him, the issue isn't that it's already public. It's that, the order here has to comply with. And while I think there is some correctness to that, the court can't not enforce its order. The court can't just let people get away with violating the order. But the problem is it really does go to the proportionality. Because you can't just be a hard ass anytime something minor takes place. He said, he's given this colloquy at the beginning of every day. No reactions, no facial expressions, nothing like that. We got some people crying in the courtroom. What if somebody yawns? Are you going to be a hard ass and like boot them out? No. So, I mean, there is kind of a fine line, but at the same time, it just also really speaks to the importance of being so careful about what you order, because you really do need to hold firm. If you're going to order it, if it's worth ordering, then you kind of need to enforce it. So I do appreciate that, but I don't agree at all that, how long it was on the screen and the fact that it was already public and things like that aren't relevant. They're very relevant because they tend to show nobody was trying to do it and it didn't really have any significant impact. So bottom line, defense wants him to reconsider his denial of the blanket ban on the cameras, or in the alternative, just ban today in the September the 1st. Mr. McBride for the state proposes what I proposed while we were on the break with the judge watching the video, that they can do a delay. He said he proposed a 30-second delay on the live feed before the video is streamed out. Says he spoke to the media and their attorney, and they don't have the capability to do that today, but it would certainly be possible to order them to look into that for purposes of avoiding problems in the future. He says the defendant just has one more expert today. It's the DNA expert for the ATF. The reports are already in. They've already been published. So it's not the same risks today if the cameras are here as it would be with witnesses who would have additional unadmitted evidence. The media says we're learning, we're refining our processes. Everybody is learning. He says, I remember there was a time when the camera was placed in a location that was causing challenges, and so the court moved it. And we're all getting better because of that. In fact, the media operator was the one who beat us all to the punch in terms of solving the problem. So according to him, the procedures that are already in place, even if they're not absolutely perfect, every single second of the trial, they are adequate. And so he doesn't think that a punishment or sanction is appropriate, that the interests have been already been balanced correctly. And so let's just proceed without any kind of further sanction. We get the judge's ruling. Defendant's rights are paramount, but transparency, while fundamental, also has to be balanced with it. Finds the order prohibiting the publication of the Exhibit 16 was violated, and compliance with the court orders is essential in all proceedings. He's denying the request for the sanction to ban the cameras categorically, revisit his prior ruling on the blanket ban. He's denying that, says his analysis as to that ruling remains unchanged. But the alternative motion to ban the cameras today and September the 1st is going to be granted in part and denied in part, in that the media is no longer going to capture any of the exhibits displayed today. As for September the 1st, the court's going to reserve on it. So we still have that hanging over us too, right? The September the 1st. That's not before the court. Doesn't want to pre-rule. It's not before him. Because it's possible it wouldn't happen, right? Possible nobody would ask. In the abstract, it is. It wouldn't violate the laws of physics for nobody to ask to televise, but we all know. We all know they're going to. But nevertheless, not before him. So if the motions are filed, the court will entertain those motions ahead of the September 1st hearing. Of course they're going to. So we will have a hearing in this case before September the 1st because this is going to happen. And they're going to all, go back and forth about whether there should be cameras at the September 1st hearing. So the bottom line was we, the public, got punished for an accident that happened in the courtroom that wasn't willful, shouldn't have justified a sanction at all, but there we have it. There we have it. So to the extent that this issue continues to hang over us for the September 1st hearing, I very much hope somebody points that out. There's no finding of willfulness in any of this. There's no finding of willfulness, so there's no basis for anybody to be sanctioned. That's just so inappropriate to spank us at home. We are the only ones that had a consequence because of this. Hopefully it's a one and done, and this is just a product of a very long week. Everybody's tired. Everybody's frustrated. Maybe tempers are a little short. Maybe this is what Judge Graff short temper looks like. Still haven't seen him lash out. Only had a couple times where he dropped the hammer. Once with Michael Burt. You're done. You said one more question. And now here you are asking more. One more. Time for you to move on. And then once with, my impression anyway, with Erica Kirk's lawyer, with Mr. Nyman. Mr. Nyman. But anyway, it's just very irritating. This whole thing seems so ad hoc. It seems so ad hoc. It's just kind of developing on the fly. And while that's kind of always going to be the case with stuff that you have to balance, it's an evolving situation. There's rights you have to balance. You always kind of have to be rebalancing them at all times. It just doesn't feel like there's a real clear set of reasons and principles that is guiding that ad hoc weighing. Mr. Grunander spoke first. He says, today we're just continuing the taking of evidence. But you said sometimes we need to take time to save time. So that's what I'm doing. He says we've spent 5 hours from defense witnesses so far, and there's no doubt they're entitled to call witness, but just reminds everybody of the purposes of the hearing. It's probable cause determination. Mr. Burt has invoked reliability many times as the court's the gatekeeper to admissibility, but he says that's decided when the court makes the admissibility determination. It's decided for that purpose. That's the really only reliability standard that has to be met in this process. Doesn't meet the rules of evidence, because any further reliability beyond that is really going to the weighing. It's going to, is this credible? Should you put a lot of weight in this information that you're getting? And I think he's right. I do think that is something that Mr. Burt did. That it's clever. It's clever, but it's rhetorical. He was equivocating. He was equivocating with this reliability term. It means different things, and so you use all of the meanings kind of interchangeably. But it's supposed to have this limited meaning for this hearing, reliable hearsay. That's defined specifically in the statute. These, laid out definitions, specific things that are identified as being reliable hearsay per se. And that includes these expert reports. And so Mr. Burt is using the more broad understanding of reliable. Well, would I want to rely on it? Should I question it? More colloquial kind of verb, but he's using them interchangeably as if that's the meaning of the statutory term. So Mr. Grunander kind of called that out. He's like, you're really just going to credibility in this, and you're not allowed to do that. Rules are very clear. So he's announcing that at some point the state is going to lodge a standing objection if it continues. He goes through, cites all kinds of case law that's just basically saying, even if the defense calls this witness and they score points with the witness, it doesn't matter today. It's not something that the court can take into consideration. They can't weigh it. They have to give all of the benefit of the doubt to the state. The credibility stuff is up to the fact finder at trial. And even if she gets on the stand and recants her findings from the report, that's not always going to be enough. Even recantation isn't always going to be enough because of the inferences that cut in favor of the prosecution, given the nature of this proceeding, this particular process. He says, you've heard 4 days. The evidence is overwhelming. It's devastating. And so what's the point of more extended, drawn-out testimony? Mr. Burt responds. He's got his hackles up a little bit, perhaps. He doesn't know what's being requested. Well, the state, they're not requesting anything. They're just saying, putting you all on notice. This continues. We're going to object. Request a standing objection. He says, we discussed before with the state about before the state would make an objection to us calling these witnesses. We had this conversation and reached this agreement so that we wouldn't have to fly witnesses out if they would not allow them to be called. And so the states waived that. The states waived that. And I thought about that and I was like, no, they didn't. No, they didn't. Because I remember that from that hearing. And Mr. Grunander said very specifically, we are not waiving any specific objections we might make based on the questions asked. So not quite a meeting of the minds on exactly how this was going to go down. When the state is agreeing you can call the witness, what that means is that they're not going to interfere. They're not going to, it's not even going to be a subpoena. I guess it would be. It's just they would have to go through TUI. They have to go through TUI to subpoena the federal officials. And so, federal analysts are protected under that. So it would be similar to Lance, where they would come in and ask to quash it. Just quash that subpoena because the defense doesn't have the right to call him in. That's what the state could have done. In order to resolve that, they said, all right, we'll let you go ahead and call him in, but we are not waiving any objections to the questions you might ask. If the direction you take it is not proper, we're going to point that out. I really think this is a defense that's good at taking an inch and stretching it into a mile. Slowly boiling the frog into a stiff old boot sitting on somebody's plate up there in the Klondike. He says that the state problem here, state introduced these reports through non-expert witnesses and then they cherry-picked what they presented. And so that's that's the necessity for calling the witnesses. So in any event, everything he says is going to be done by noon. Questioning, cross. It was pretty close. Got that one in just under the wire. So that was that. We called her Caitlin Oliver, the ATF DNA section chief. She's been with ATF for 9 years. Before that, she was with the Jefferson County Sheriff's Office in New Orleans as a DNA analyst. She's been doing DNA for a while. She received a request to do DNA testing for the state in September of 2025. An exhibit is pulled up, and at this point, everything goes mute. The courtroom goes mute, and things are clearly still happening. And we're like, so what's going on? What's going on? The judge says we can't see the exhibits on the camera, but there's clearly hearings still going on. What's with that? We don't get to hear arguments now? Testimony? Is there a voir dire of the witness happening? And I don't know how long it total was, but probably a good 5 minutes. Just sitting there watching the quiet stream, watching the judge, hearing nothing. Finally, it came back on, and I guess they had to clarify. It doesn't mean, the order isn't that we can't hear about the exhibits either. It's so overly complicated. The whole thing has gotten so overly complicated. So there was a chunk we didn't get to hear because of the camera being on mute, but we did get it back. And where we took it back was talking about, I realized we're just back in the same conversation we had the other day with the other DNA analyst, with the one from the FBI. This one's from the ATF, that one was from the FBI, but we're asking exactly the same questions. We're talking about the terms evidentiary support, the possible contributor. We're talking about their language policy. More of that. Unlike the FBI that uses the language scale, you remember they had that chart where, depending on the likelihood ratio, there was specific language that they would use to describe it. And so very strong support for inclusion, strong support for inclusion, or limited support for inclusion. I mean, I don't even remember what the levels were. I think it was strong support, limited support, uninformative, limited support for exclusion, strong support for exclusion. But ATF doesn't use that. Their view is that those kinds of things add a subjective, it's putting your finger on the scale, it's coloring it. So their view is that that's what the likelihood ratio itself is for, the statistic. If it's a big number, then you know, weighty. So it stands on its own, and all they specify then is whether that is representing inclusion, exclusion, or uninformative. Can't use it, can't draw conclusions of it. So all the same stuff. They can't say it's infallible. They can't say it's 100%. They can't say there's no error rate. They can't say it establishes absolute identification of a source, no matter how big the ratio is, which is true. That's not what the ratio is doing. That's not what the statistic means. I want to clarify again, because this gets very complicated with the DNA, the technology, the statistics, the way they communicate what they're doing. The likelihood ratio is a comparison of two assumptions. Neither of them is known to be true. They're assumptions. And it's looking at if these are both of our assumptions, what's their relative likelihood that Tyler Robinson's DNA is part of the sample, or It's all unrelated, unknown people. Which one is more likely and how much more likely? So it's not saying it is, it's just saying it's massively more likely than that it's for completely unknown, completely unrelated people, which doesn't really exist in the world we live in. It's an abstract thing because we live in communities where we have relations, we have parents, we have siblings, we have cousins, we have uncles. We have people that are related that share parts of our DNA. And so it all just gets very complicated trying to translate that into real world terms. But that's why it's so important to appreciate. It's abstract and it's an assumption. It's not a base truth. It's not saying we're comparing, saying how likely this base truth is. We're just saying if we assume the possibility of both of these assumptions, how likely are they relative to each other? You can't state anything with 100% certainty with forensic science. I appreciated her saying that because, yes, that's what makes it science. Science is never 100% certain. Is there anything 100% certain in science? Death and taxes? I mean, that's not science, but... And I mean, that's just more and more the case. I think the more sophisticated we've become with our knowledge, we are now more probabilistic thinkers. Thank you, Karl Popper. Falsifiability has made us more knowledgeable. Our knowledge base is like expanded exponentially with that kind of formal skepticism and the ability to quantify it, assign mathematical terms to it and stuff. So yeah, more of the same language stuff. We did talk a little bit about consumption, their process for consuming, doing the consumptive testing. It sounded like we got this list of samples. Some samples were consumed in the analysis, and these were identified. We had this list, 1.4, 1.6, 1.9, all these variety of different numbers. And then we also had a note that extracts were retained for the remainders. And we clarified these were swab samples. And so the question is, does that mean the swab was consumed, but some extract was preserved? And she said yes. And so I'm unclear from this questioning if the 1.4, 1.6, 1.9, if these are the swab, if that's what she's saying. But then for some other, there were like... either they weren't swabs. It was very unclear. I couldn't tell what he was saying. I couldn't tell if he was saying there's no extract left for some of these. So it was just, that needs to be cleaned up. Unless the point is to obfuscate, with the jury, sometimes their point is going to be to obfuscate, and that will probably be clear when it's the case. But this was clear as mud. So what's the status? Is there any left to test or not? Didn't just like get there directly and explicitly. Talking about the major and minor contributors again, and doesn't allow them to speak to like the major minor doesn't say anything about like who touched it recently, who's handled it more than the other. It doesn't give them any information about the manner of deposition because there's just so many factors that lead into DNA being deposited and persisting. There's this funny little change. Any other limitations you can think of? She's like, is there something specific you're thinking of? You're like, yeah, there is. So then we have to go to another publication, a NIST publication, National Institute of Standards, and I still can't remember what the T stands for. Techniques. Anyway, And then they have a little argument about, a little language argument, which is funny since, this whole thing started because Mr. Bird is nitpicking the language. Now we have a language argument because he's calling it guidance. And she's like, well, it's not guidance. They're not a regulatory body. It's just a report. But these aren't like these aren't regulatory guidelines like we would get with somebody that actually has authority to tell us what to do. So they quibble about that. But based on the NIST report, does she agree? You can never know for sure what the number of contributors are, the true number of contributors. She does agree with that. In their lab, when they report a likelihood ratio, they cap it at 1 trillion. I kind of like that. I do. I kind of like that. I hadn't heard this. I wasn't aware of this. I don't think I've seen this before. With the FBI, of course, we got the quintillion and the octillion and stuff like that. And people don't know what those numbers mean. And not only do you not know what it means, it's not conceivable. It's not conceivable. How do we can't really conceive a trillion. We're very material beings, and a trillion is just so much. And so then when you take the trillion and you multiply that by, a trillion times, it's not meaningful. And so even though a trillion is like kind of at the limit maybe of where we can grasp like massive, it is at least like at the limit of our comprehension that way. So that's why they cap it that way. It could be more, but they're just never going to say it is more. They're just going to say at least a trillion. At least a trillion. So that it's meaningful and you don't just like, well, what on earth is that? How do you even comprehend it? They don't make source attribution statements. They don't say it's so-and-so's ID or so-and-so's DNA. Can't do that. They just say their support for inclusion. That's their language. And then the one thing I felt like got elicited out of this cross exam that was it was good. This is good. This is, if he had just done this, done this a few times with a few different propositions, it's going to be so much more impactful. Do you agree that the statement, Mr. Robinson's DNA was found on an item, is not scientifically defensible? Yes, she does. That's the whole point of these language restrictions. That's not a scientific claim. It's a conclusion that you might make. It's like it's a belief you would have. It's probably the best way to put it. It's a belief that you might have based on the weight of a certain evidence, but you can't know it with certainty. More about the likelihood ratios. There was a statement in here, the one that was the one I'm like, I think I might need to look at this NIST report, because it was saying it can't imply uniqueness within the population. I really feel like that's the entire thing that it does. It is about uniqueness. It just doesn't show rarity in the population. It shows it's very unique, but it doesn't show that that makes it rare, because unique things can recur. You can have triplets. A lot about can't deal with deposition, how and when DNA gets to be deposited. Talked a little bit about, transfer, secondary transfer. I shake your hand, my DNA gets on you, you then go and drink your coffee, and you transfer my DNA onto your coffee cup, so my DNA is on your coffee cup even though I never touched it. Very well established phenomenon. Stable over time, she says. It requires environmental insults. I like that expression. I really do. Environmental insults like heat or humidity can cause degradation. So then we look at the Dremel report, And again, they had the elimination sample. Remember, that was a big deal last time because they conflated the different kinds of analysis that you do, and the elimination sample is also, it's an assuming, it's an if, because the whole likelihood ratio is based on just ifs, right? So it doesn't really matter if the elimination sample doesn't have strong support for it. We're just entertaining it as an if. And so if in combination with this other person being present, that's much more highly likely than some totally unrelated combination, then you have at least, some sort of probative information that you can use. But so they did elimination samples with this again, talked a little bit about that. They also get them from agents just in case there's contamination and stuff like that. That's standard practice. They got elimination samples from Tyler's mother, Tyler's father, and from Lance. And that's because they're associated with his home. And so things that are in the home, you would assume their DNA might be on it. So you have their DNA so that you can use them as elimination samples in case they are one of the contributors. Found support for inclusion for many of the elimination samples. Mostly Tyler's dad with the rifle stuff, with the gun. On the Dremel tool, there was Lance, support for inclusion for Lance, which is not surprising. Lance told him where it was. Sounds like it's Lance's Dremel. Item 1.6. Really wanted to go back to, if I can find it real fast without having to tear through everything. I was like, I want to go back and look at, that testimony, see if I can spot what exhibit that was, which item that was, which swab, because I was curious about the fired cartridge case. But somebody needs to chart out all the numbers and stuff from this. I haven't done it yet. I probably will. I'll go through my notes and do that at some point just to keep my thoughts organized, but I haven't done it yet. Anyway, I was curious, but the bottom line is, it doesn't sound like Lance is on any of the gun stuff, which is really important, I think, to the extent they want to entertain the possibility of pointing the finger at Lance. His DNA not being on that gun while his DNA is on other stuff in the house. It's on the towel, it's on the screwdriver, it's on the Dremel, but it's not on the gun and it's not on the bullets. I think that's going to be a hard sell to a jury. Talk more about next gen. They don't do it. This was about the point where the state starts to object. Because he's saying, this is beyond the scope. We're going back into the isoallyls. We already heard about this. This has all been super cumulative. We already heard almost all of this. So they object at this point. Mr. Burt's like, oh, let me just this out and then we'll just move on. And so they do. They talk about the isoallyls and then point out, oh, you could sequence them. And so we object again. She doesn't do sequencing. There's no point really in talking to her about sequencing. She's already been clear she doesn't do that. Mr. Burt's like, well, but it goes to the weight of her comparisons. If you're saying it goes to the weight of her comparisons, you're saying it has nothing to do with PC. Weight doesn't matter for PC. I was like, please jump on that, Judge. He literally just gave you the, improper basis. One might say he's implicitly telling you that what he is doing is improper, not consistent with the purpose of this hearing. But the judge, and he's just like, but if she didn't do that, and Mr. Burt's saying, well, but that's the point. She can't draw conclusions. that she did because she didn't do it. That's the argument he wants to make. And Mr. McBride says, that's not accurate. Not doing next-gen sequencing doesn't mean you can't draw conclusions based on the technique you did do. Which seems a fair point, doesn't it? So we have to move on from next gen. No more next gen. We start talking about exclusion, but it's kind of not. She explains some complications when you're dealing with mixtures because of the degradation and possibility that things can drop out. And so if there's no information at something, that's not going to exclude somebody. No information isn't going to exclude somebody. It just means you have nothing to work with. And again, he goes into the sequence. If you sequence, Mr. McBride objects. That's not what she did. And Mr. Burt's like, but if it could have been excluded and it wasn't done, then that's relevant. The judge sustains that. He's had enough of the sequencing. It's clearly weight, Judge. It's clearly weight. Plus, we've heard all this already. Bottom line, all of the samples were mixtures. Also a good point. If you had stuck with can't say Tyler Robinson's DNA is on any of this stuff, that would not be scientifically valid. And all of these samples were mixtures, and that complicates things there. Multiple people's DNA is on this stuff. Seems like those would have been really good points that would have taken significantly less long and also not potentially gotten lost in the mix. Goes into the likelihood ratios. Does it vary with the number of contributors? The same stuff we were hearing about before. She's like, well, it goes to the weight. The likelihood ratio just speaks to the weight. So she says it's more complicated than just you have more contributors, because if you have more contributors that are all contributing really high quality samples, that could be one thing. You could have very high quality, but you could also have a single sample that's very low quality. You only got like 4 alleles. You can't get good information out of it. That's going to have a very low likelihood ratio. So that's an important distinction that she made, and that's right. So it's not like directly caused by the number of contributors. It's just one factor. It's not a measurement of the quantity. The likelihood ratio is not a measure of the quantity. And as far as determining the number of contributors, she uses her training and experience. That's a weak point. This one could have been also developed. You don't know. I mean, he already kind of did with the policy. That's all you need to know. You don't know how many contributors there are. You can't say Tyler's DNA was on this, and there's lots of DNA on it that would not belong to Tyler. There's a mixture of DNA. For some reason, we spent a while establishing that her standard operating procedure says that approximately 70% of 4-person mixtures present as 2 or 3-person mixtures based on the alleles present. Okay. Okay. Why does this matter? What's this have to do with PC? One more SOP thing. Yeah. That was where we ended. 70% of 4-person mixes present as 2 to 3. This must be like some ground truth testing stuff, some black box stuff where they create a mix and then they subject it to blind testing so that they can see how good people actually are at counting, identifying how many. So Sounds like a situation where maybe they created a bunch of 4-person mixes and I don't know, ran it through their program or had people read the electropherograms, I mean, whatever, and people were concluding 2 to 3. That's the best I can come up with. But that would be like an error rate kind of thing. That would seem to relate to an error rate in identifying the number of contributors. I mean, didn't hear anything about that. So I'm just again, I'm lost. I'm lost. There was good stuff in here, but it was so buried. The judge wanted to know if we should break. How much cross you have? It's almost lunch, right? Mr. McBride's like, I got 20 minutes. Judge like, all right, let's power through. Power through. We're just going to get it done. So we got a lot of the same from Mr. McBride. Accreditation, training, are these things accepted, et cetera, et cetera. He asked what may have been the best question of this hearing so far, in my opinion. Not in necessarily like substantive terms, but just it's a great question in terms of how it is presenting the information contained in the answer. Where on the firearm was there evidentiary support for the inclusion of Tyler Robinson? It's such a good question because then we got this list. The stock, the grips, the butt plate, the trigger guard, the bolt, the forend, the barrel, the optical accessory, the underside of the receiver after disassembly, and 130 casing and two cartridges. Long ass list. That's how you present information. That's how you present information, because that sounds like a massive amount of DNA all over this gun, doesn't it? Doesn't it? It sounds like there is no part of this gun he hasn't touched. It's his gun. His DNA is all over it. Right? That's what the jury is going to hear. Great question. Everybody in this process, I think, would be very well advised to make more of their questions like that. Think about how you can make more of your questions like that. He also points out this probability. So he clarified the probability statistic, and I'm so glad he did, because this was kind of dropped in as an afterthought during the FBI analyst testimony. There was like this one line where they included this, more or less likely than member of the population or whatever. And I was like, wait a minute, because this sounds like a population statistic, and that's not what these things do. But she explains it's just another way of expressing the likelihood ratio, which is that the probability of an unrelated person contributing to this level of support the probability of an unrelated person being present and generating, this level of support is less than 1 in 1 trillion. Just another way of stating the likelihood. Might still be different than that population one. I don't know. I'm still like side-eyeing that population one. Not sure what that is. Yeah, just kind of clarifications about some of the stuff we already know, the details of the report. As far as the fired cartridge case and the unfired cartridge case, pretty sure we're talking about the ones from the gun, but again, it just wasn't 100% clear. Would like that to be crystal clear, because we also had the unfired cartridge case, or the fired cartridge case at his house, remember? The ones there was the engraved one, and there was a few other ones, and they were on top of the safe in the room, like the extra room next to his room. It really would be helpful to know. I'm pretty sure he was talking about the fired cartridge case with the gun. And this, I think, was important because it spelled out, pretty sure for the first time after I went back through my notes and was trying to make all sense out of all this kind of stuff that we heard, that one's only a mixture of two. That one's only a mixture of two. So that's like really some of the strongest DNA evidence they have. It's really not complex to the point where deconvolution causes a lot of foundational validity problems. And the fired cartridge is really the most important piece of this whole puzzle, isn't it? Because, yeah, it could be his gun. It could be his gun, but, you know, somebody else could take his gun and shoot it. The fact that it was loaded with this engraved cartridge that's got his DNA on it, well, support for inclusion of his DNA, strong support for conclusion of his DNA on it. That to me is probably the most incriminating thing. Not the most incriminating thing like overall that we've seen, but just as far as the sum of the DNA evidence, the cartridge, fired cartridge, the bullet, that's a pretty big one. So the fact that that's probably some of their best quality DNA evidence, not going to be helpful for the defense. They're going to have a hard time with that because they're not going to have a good scientific argument that this is problematic. Some of these other ones, the 4 or 5 person mixes, yeah, maybe they might be successful at getting some of that limited. But if you have the cartridge casing in there, if you can get, you know, at least some of the bullet stuff, some of the gun stuff in there, some of the 3 person mixes and whatever, I think they're going to be pretty gold. So that is a very, very tough position for the defense to be in. Brief redirect from Mr. Burt. We established that the trigger and the trigger guard were swabbed together. They weren't swabbed separately. We hate that. We hate when they swab things together. Just swab one. Just swab, not just because then you don't know what came from where, but also you're contaminating the thing. You know, whichever part of it you swabbed second is contaminated with where you swabbed first. Don't do that. Don't do that. This goes back to the retesting. Which one did she swab first? I hope she kept note of that, and I sure hope it wasn't the trigger. Because if she swabbed some other part of the gun and then swabbed the trigger, we have the potential for contamination on the trigger. I really hope she didn't do that. Most of this was repetitive again. We established that some samples have more than one major contributor. Like this seems to be, I mean, just in, not like in the abstract. I'm not sure that that even happened here. Just in the abstract, that's the thing. In the abstract, there's a thing called a random match probability statistic. This is not that, she says. It's just a different way to present the likelihood ratio. She's not stating sort attribution. That's why they give the likelihood ratio. That's what helps people weigh how important this evidence is. That was it. The defense rest. No rebuttal from the state. We had that matter, brief matter, that was brought to the court's attention about the publishing the enhanced, the zoomed rooftop video from the Low C Center. We pause so Ms. Visser can give a quick put on the record. She phrased this expertly. We've advised Mr. Robinson about his right to testify at this hearing, and he is following our advice to not testify. She's done this before. He's not testifying. He's got nothing to say that's going to be helpful, but we are going to phrase it in a way that makes it clear. We're telling him to. So you can't just be like, because he knows he's guilty. No, his lawyers told him to. He's following his lawyer's advice. Very smart that she's done that. As soon as the judge is suggesting, I'll hear from you on whether we're going to republish the thing, Mr. Nyman is like jumping up. And he's like, Judge, I understood you ruled yesterday that we would be able to. And I had understood that too, that he said they would publish it in the courtroom, not to the camera. And Mr. Grunander says, just to clarify too, as in accordance with the ruling this morning, it's not going to be published to the camera. So the judge says it does adhere to his prior ruling, and he's going to limit the live stream to audio only, just so that we don't see, and which was kind of silly because there's no audio on these surveillance videos. So it doesn't matter if you do or don't. We weren't going to hear anything either way. Felt that's the least restrictive means to accomplish what's being requested. What's the compelling interest in having it visible in the courtroom and not on the camera? What's the compelling interest? Forgot that part of the equation vis-a-vis the, access and so forth. So they play it. We watch them. We basically watch the judge while it's playing. And then that's it. So at this point, preliminary hearing is adjourned until September the 1st, 10 o'clock for the argument. He's allocating 4 hours total. And Mr. Robinson will be present in person. Then, of course, there's a variety of reports from the courtroom about what the video shows. And as you might expect, there's some disagreement. There's some agreement. There's some disagreement. And so, where are we at? Not being able to see it for ourselves and know who's telling the truth, who's exaggerating, who's just flat out lying. We don't know. In a way, kind of a just ended it kind of like go figure. Kind of how things have gone. That's sort of the trend that we ended on. And I started off this hearing so optimistic. I really did. Judge Graff seemed so on the ball, so really getting it when it came to the transparency and the whole problem with keeping the stuff behind the closed doors. And it really was just kind of one of these things for me. Really, I'm not going to say it went off the cliff. We weren't like full Thelma and Louise here, but really did not maintain the heights that we had, I think, prior to this point. So don't really like the trend that it's on. That said, this is a very particular hearing. It's not going to happen again, but there also are going to be other evidentiary hearings in the case. I mean, when they have I'm already anticipating pretrial and motions in limine. Motions in limine are, what sort of pre-alerting the court if hey, they're going to offer some exhibit and I think it's not admissible for some reason or another. Not because of big, suppression, police got it illegally and stuff like that. Just purely like rules of evidence stuff. litigate that in the motions in limine. Is that all going to be closed off? I feel like at this point it probably is. Well, let's do the fun stuff then, shall we? Because now all the evidence is in. All the evidence is in. Guys, I have gone through, I'm going to be refining this over the next couple of days. But I have gone through and, why it's not doing that. I've just sort of like made a list of, I don't think you can kind of see it, but it's like about a page and a half. This is my list of what the evidence was. What's the state's evidence was. And just kind of went through in order. So kind of every day, here's the little things that came in that they are going to argue plays some role in connecting Tyler Robinson to the crime. So let's start by looking at the crimes themselves. What exactly the state's going to have to prove. Clearly this one right here, this is the one that matters. Aggravated murder. Going to be by far the most significant charge on any document. And it's pretty straightforward. Intentional murder by Tyler Robinson of Charlie Kirk on September 10, 2025 in Utah County. The Charlie Kirk, the Utah County, the September 10th, these things are not going to be in dispute. Intentionally causing the death is probably not going to really be in dispute either. It's a shooting death. It doesn't seem like there's really going to be a lot of dispute about that. And don't think there's probably an argument that somebody accidentally hit the trigger. So that's not likely to be significantly in dispute. It's really this. It's Tyler James Robinson. That's the critical question. And then really the aggravator. The defendant knowingly created a great risk of death to another individual other than Charlie Kirk and the defendant. I was thinking about this because I was thinking about the other day, somebody had a great idea in the super chats. That's what about just the panic that this could cause, and that could count. I'm like, I love creative thinkers. I hadn't thought of that one. It's very creative, and it's possible that it could. It's possible that it could, but then I'm thinking, is that a great risk of death? Is that a great risk of death? I mean, I don't know. It could be. I mean, people do get trampled and die at music festivals and things like that, where there's big crowds and crushes and stuff like that. So yeah, maybe could. But those are going to be the main things, right? So Tyler Robinson. How do they prove it to Tyler Robinson? How do they prove the great risk of death to another individual? We have this victim targeting enhancement. We have this violent offense committed in the presence of the child. Felony discharge of a firearm causing serious bodily injury. This is going to be the same thing. The issue is just going to be Tyler James Robinson. That's really it. Discharged a firearm in the direction of Charlie Kirk, knowing or having reason to believe that Charlie Kirk may be endangered. I mean, if you point something at somebody specifically and shoot them in the neck, you generally are gonna, that's going to be established. And the act caused serious bodily injury. Yeah, you kill somebody, that's going to be established. So once again, this is really an identity question. It's really all they have to prove. Tyler Robinson. Don't think there's really going to be a case that this was accidental. Don't really think there's going to be a case that he was just trying to scare him or something and then just like oopsie hit the target. That's not particularly plausible. Don't think that's going to be in dispute. Same enhancements here. Victim targeting, presence of a child. Obstruction of justice. Tyler James Robinson with intent to hinder, delay, or prevent the investigation, apprehension, prosecution, conviction, or punishment of any person regarding conduct that constitutes a criminal offense. C. Concealed or removed the firearm used to shoot Charlie Kirk. And the conduct that constitutes an offense would be a capital felony or a first-degree felony. So they're arguing concealing or removing the weapon is obstruction of justice. Count 4, obstruction. Another count of obstruction of justice. Same thing. This is the next day, on or about September 11th. Tyler Robinson, with the same intent, destroyed, concealed, or removed the clothing he wore during the shooting. And the conduct that constitutes the offense would be a capital felony or first-degree felony. Destroyed, concealed, or removed his clothing. Then tampering with a witness. September the 10th, Tyler James Robinson, A, believed an official proceeding or investigation was pending or about to be instituted, or intended to prevent an official proceeding or investigation. He's trying to not get caught. And B, attempted to induce or otherwise cause his roommate to 2, withhold testimony, information, a document, or an item, to wit, directing his roommate to delete incriminating text messages. The count 6, tampering, same thing, September the 11th, next day, inducing his roommate to withhold testimony or information, to wit, directing his roommate to stay silent if police questioned the roommate. And finally, the 7th one, violent offense committed in the presence of a child, alleged committed criminal homicide. This is going to be dependent on the verdict on count 1. These are going to be related. So whether they find aggravated murder, some lesser included offense, second degree, something, committed criminal, that would be established. So those will go hand in hand. This will just be an add-on. In the physical presence of a child younger than 14 years old, with knowledge that a child was present and may have seen or heard the commission of the criminal homicide. That one also has the victim targeting enhancement. Okay, so these are our 7 charges. And so what I'm going to do here, I want to work through these backwards. So that we can we can talk about, we can brainstorm about what we heard over the course of the week. And are these charges likely to go forward? Did the state meet its burden on these? So to meet the probable cause standard, remember, we don't need proof beyond a reasonable doubt. We don't need unimpeachable evidence. We are taking for granted that what is being presented is good, it's solid, we're giving it every benefit of the doubt because that's how the probable cause determination works. The real limitation is just it has to create a direct link. If we believe it all, it creates a direct link. It can't be speculative. We can't be speculating. They can't have to fill too many gaps to get to Tyler Robinson committed this crime. And so starting with count 7, we know that there were children present because there was a video, on the first or second day. I think it was probably the first day. Maybe it was the second. No. We had the different videos played. We had the lady who had the children. We had Ty Phillips. We had the TPUSA video the day that all those were played. One of those very specifically was the video showing young children present. Didn't have a time as far as we know. It wasn't at the time of the shooting. It wasn't depicting the shooting. So possibly that could be an argument. Is it unreasonable to infer that the children were still present? It's going to depend, I think, on some of the details of these videos. And then again, we also we haven't seen them, and that includes the ones of the shooting. Don't really know for sure what you can see from those videos. Do they show children younger than 14 years old? That's going to be a question. We know there's one video for sure that shows kids, but it's not at the time of the shooting. Is that going to be enough? Is it a reasonable inference? It could be, depending on the video. But I think this right here is more of the question. With knowledge that a child was present and may have seen or heard the commission of the criminal homicide, if Tyler is up on the roof of the Losi Center and he's never gone into the amphitheater, after the like last time he was down in the area, pretty sure it was before 11 o'clock when he had like been in Chick-fil-A and ate his food and all that, and then went into the wooded area. And then the next video we have is the change of clothes and the guy coming onto campus. Went straight to the roof of the Losi Center. What's our proof that he knew any kids were there, that he can see the audience, that he can perceive, that you have a good enough viewpoint from the rooftop to see like distinctly in the crowd, here's kids in the crowd. I don't think we really got a good foundation to be able to conclude that one way or another. I feel like it would have been really simple. Do that with Mr. Bagley. You just ask him, were there kids here? A lot of kids? Did you see a lot of kids around? People bring their kids? Were there kids around the area of the stage? And that would have been enough, because then you could at least infer, there's kids in the vicinity. We could, if we're, it's still, there's still that link there. How do you show that he saw them? So really, ideally, it would be something like somebody who'd been on the roof of the Losi Center describing, what can you see from up there? Can you see people individually? A combination of those kinds of things. Then you'd be able to infer. You'd have the factual basis. Kids were present in the audience. It's possible to see kids in the audience from the Losi Center roof. Tyler was on the Losi Center roof. Therefore, we can infer he saw the kids, right? That's the logical chain you take. But they really didn't do that. So they're really, I think, dependent on these videos and what the videos show. But even with that, there's still a gap because of the distance from the Losi Center. So I'm going to make a call that count 7 might not survive. It might not survive. This one, I think, is on the cusp. Could get thrown out. Tampering with a witness, count 6. Most of this information is coming from the text messages themselves, the interview with Lance, so on and so forth. So we know he did in the text messages tell him, don't talk to the police, ask for a lawyer. I don't think that's constitutionally permissible to charge somebody for giving that advice. That is Lance's right to state. He doesn't have any obligation to speak to the police, and he has a right to stay silent. So I'm very, very skeptical that count 6 constitutionally can be charged. That's what I would be looking at. I'm on the defense team. That's just a gimme. I'm researching that. I'm briefing that. That's part of why I've requested a 30, I wanted 40, but I'm getting a 35-page brief. That's part of the reason why. I don't think they can constitutionally do that. But count 5, directing the roommate to delete the incriminating text messages. This is just going to depend on, we have the foundation. The text message chain itself, it's in writing. It's on the phone. We heard it was corroborated, it's validated by a Celebrite extraction. Tells Lance, delete this exchange, delete this thread. So at this stage, with the inferences and with the testimony, this is Tyler in the communication, this is Lance in the communication. The communication itself kind of establishes this one because he's like, shit, I'm going to get caught. delete this. He's trying to prevent the investigation from coming down on him. He's trying to prevent, you know, the charge from landing at his door. Delete this. If they find me, they'll be able to charge me with murder. But you delete the text, might make it harder. Count 5, I think, he's gonna be bound over on. Obstruction based on destroying, concealing, or removing the clothing he wore during the shooting. Now, we didn't hear anything about this at the preliminary hearing. We heard nothing about the clothing he wore during the shooting. We know he changed clothes, right? Under the state's theory, we're giving the inferences to the state. We see the guy that comes in the morning in the maroon shirt and the shorts, and then the guy comes back at noon, goes on to the Losi Center. He's wearing different clothes, but the state's saying it's still him, and it looks similar, right? Looks similar, so we can draw that inference in favor of the state. May not be beyond a reasonable doubt at trial. They'll still have to get there. They tell us there's lots more video we haven't seen, but for purposes of this hearing, we can draw that inference that it's the same guy, changed clothes. And then the next time we know what he's wearing at all is when he turns himself in the next night at the Washington County Sheriff's Office, and he's back in the, maybe not the maroon shirt, but at least a maroon shirt. But my recollection is that information came from Mike Mitchell. It was Mr. Mitchell who had reported what Tyler told him about disposing of evidence, that he like buried his clothes or something like that. So assuming, you know, that's what's in it, then it's going to be bound over, I think. You know, trying to hide the clothes is pretty clearly, you know that they're incriminating. That's why you did it. It's one of those acts that kind of speaks for yourself. You don't just bury your clothes for no reason, you know. You bury them because you know they're going to get you in trouble. So count 4, probably going to go forward. Count 3, the obstruction of justice based on concealing or removing the firearm used to shoot Charlie Kirk. This one I struggle with too. Because I'm not really clearly sure what act are we talking about. Are we talking about the wrapping it in a towel is obstruction? Are we talking about putting it in a bush? Because like, I think for most of us, for me anyway, I look at this as like, well, he left the gun at the scene. And it just, this seems to be an interpretation of obstruction that is a little bit too broad. You know, if removing something from a crime scene is all you have to do for obstruction, then it just seems like leaving the scene would achieve that. You would always be guilty of obstruction anytime you committed a crime and didn't get caught in the act. That seems really broad to me. So I have a little bit of skepticism about count 3. If he had done anything to try to destroy the firearm, no question. Thrown it in the river, something like that, no question. But this didn't. I mean, is it the covering it up with the towel while he left the scene so that like you wouldn't be detected? Concealing it? so that it wouldn't be caught on camera? Is that the obstructing? I don't know. This just seems, I have some skepticism about this one. If I'm the defense team with this one, I'm side-eyeing it. I'm researching the obstruction statute. I'm researching the case law. I'm looking at all the variations on, what I typically look for in this. If there's like, I'm like, this feels like a fringe case, is I go and I look for cases where they've talked about the sufficiency of the evidence, preferably cases where they found this is not sufficient evidence to constitute obstruction. But even cases where that's the challenge and they do find it sufficient, it's helpful because they lay out the standards and stuff like that. So that's what I'd be doing if I'm the defense team. I'm looking for cases where obstruction has been thrown out for insufficient evidence, and I'm trying to see if I can analogize them to this. So that's just my knee-jerk reaction. This seems like it just kind of is crime plus, like it's like an extra punishment for not getting caught in the act. If I do a drive-by shooting and I leave the scene, I've removed the car, I've removed the gun. Is this like an extra 2 counts of obstruction just automatically because I committed a crime? If I shoot somebody and then put my gun in my pocket when I leave, is that obstruction? Have there been any other cases where somebody has been charged or convicted with something like this? Can I find any? Somebody ever been convicted for like putting their gun in their pocket? This one is, I didn't check the Utah Rules of Procedure to see if they have a process to request a bill of particulars. If they do, I might have done it with this one, just to kind of try to get the state to nail down exactly which part of this is it that you're saying is a crime. Maybe all of it, that's fine, but just specify, like, what exactly is the act that we're talking about here? Is it the towel? Is it the fact that it wasn't on camera? Is it the fact it was in the bush? This one I could see going either way, just depending on what that body of case law says. But I'm very much side-eyeing it. It wouldn't surprise me if that one he's not bound over on, but got to do a big deep dive into the case law to figure that one out. Felony discharge of a firearm. This is all going to come down to identity. That's all it's going to come down to. Everything is on evidence. Clearly, somebody on video discharged a firearm in the direction of Charlie Kirk. Intentionally. Clear, seems like from the testimony. Somebody got up on the roof and went and got down and then shot, got up and ran away. Charlie Kirk is shot. He dies. Like that end of things is consistent with the Losi Center roof end of things. So that part, not a whole lot of problem clearing that bar. The issue is the identity. Has identity been established? We'll get back to that because that's also a big key to count one. 2 things going on with count one: identity and the aggravator. So what's our proof of identity? Well, let's go through the evidence list, shall we? I'm going to compile this and share it. So here's what I kind of identified as the things that the state introduced that they're going to argue is the proof. Proof that Tyler Robinson shot Charlie Kirk. We start with the screwdriver that they found on the Losi Center roof. It has the DNA on it. There's a sniper pad on the roof where the individual on the camera is seen. We have all of the UVU footage showing the movements of the individual, connecting that person to both the Dodge Challenger and to the rooftop. We have the shoe print from the northeast corner of the low C center and the scuffs, which are corroborating the camera perspective of the person coming off the roof. We have the Ring doorbell footage that at least ostensibly shows, for this purpose of this hearing, inference in favor of the state. They'll assume it shows Tyler's car, so still there after the fact, corroborating some of the other evidence about trying to recover the gun and so forth. We have the law enforcement interaction, the guy from the, what was it called? Fork. Was it South Fork? I can't remember. The other police agency at a little bit after midnight on September the 11th got his license number, was able to identify that person as Tyler Robinson, also consistent with the Challenger. So again, now we've got link from Challenger to video guy to Tyler Robinson for purposes of all of our inferences for probable cause. We have Tyler Robinson voluntarily surrendering himself on September the 11th. That is consciousness of guilt. For purposes of this hearing, that's the inference. We have the Mauser 98 that has DNA with strong support for inclusion of Tyler Robinson all over various parts of it, in the internal components of it, in the bullets and the fired cartridge casing that are in it, the towel that is wrapped around it. We have the interviews from his parents. It's been mentioned that they did, although the details of that didn't really come in. But the Mike Mitchell interview, the 1102, that is in evidence. We just haven't seen it, but based on what it's been represented to be from the charging documents and so forth, that will contain admissions or at least implications by Tyler Robinson. We have the interview from Lance connecting Tyler with the engraving of the bullets, with the note that has a confession, with the verbal admission. He's sorry he did it, cried and said he was sorry he did it. We have him identifying Tyler Robinson on the morning footage as the morning guy, who for purposes of this hearing is going to be inferred to be the same guy as the shooter, the guy who came back in the different clothes. We have the whole text message chain that's been corroborated by Celebrite. The most incriminating thing in all of that, I mean, obviously the whole thing is like really incriminating, but the one to me, the piece of corroboration that's just like, this is really solid. I left the gun wrapped in a towel in a bush. He knows. He knows the condition it was in, where it was, that was not public. The detail only the shooter would know. That's powerful stuff anytime they can have that when it's legit. That's why there's temptation to maybe fabricate it when it's not there. That one's from my Richard Allen peeps. So yeah, that corroborates the gun that was found, the Mauser, at the scene. We have the Discord chats. It wasn't published to us at home, but it's public, incriminating statements in that. We have the fact that the note that contains the incriminating statements was burnt. Lance says it wasn't him, so that is consciousness of guilt because the inference is that Tyler did it. We have the engravings on the cartridge that are the cartridge casing, that was fired, and the cartridges that were still in the bullet that are matched to the Dremel tool and the bits that were recovered from Tyler's home that has the DNA on it. That same Dremel also matched the engraving of the spent test shot casing, test fire that was found in Tyler Robinson's house that also had his DNA on it. Is that about it? Oh, yeah, of course. The bullet jacket fragment from a .30 caliber. Bullet jacket fragment recovered during Charlie's autopsy with the cause of death by gunshot wound. And it's a .30 caliber. For purposes of this preliminary hearing, murder is locked up. He is absolutely being bound over on murder. Zero question. Kind of took me a while to get through that list, didn't it? Kind of a few things. And yeah. So then we get to the enhancement, or the aggravator. The knowingly created a great risk of death to another individual other than Charlie Kirk and the defendant. This, I think, is probably going to come down to the video as well. We talked about this the other night with when we looked at the cases that talked about the zone of danger and what that means. You have to be, somebody is within the zone of danger. It doesn't have to mean the danger is the result of the exact same act that caused the murder, that caused the death, but it has to be temporally proximate. It has to be spatially proximate. And whether or not anybody actually felt threatened is a consideration as well. We don't have any evidence of that. We don't have anybody that testified or, as far as we know, gave an 1102 that said, you know, I was afraid I could have got shot or something like that. So I think this one's likely going to come down to the video, which we haven't seen. We haven't seen like Tyler Phillips's video. He's one from the audience, from the front. As far as I know, I don't think this is the same as the one that was all over the internet. It might be, but I don't think it is the way they described it, because they described him as being pretty close to the front. So, that's going to be the key, I think, is what does the camera show as far as how close are people to the shooting? Because that's going to have to be their argument. That how's the risk created? They've already kind of implied their theory as well. The bullet could have passed through, hit somebody behind him. Maybe he could have missed, you know, and hit somebody slightly to, you know, one side. Could have ricocheted. All these things, though, they start to get a little bit more remote, you know. Like, yeah, it could ricochet. It always could. But then you also have the combination. It has to ricochet and it has to kill somebody, you know, hit somebody. And not like just, you know, in a part that's potentially lethal. You're getting a little bit more remote with stuff like that. And then if we don't have that, then I think we are like left with could have stampeded or something. And that, I think it's very clever. I really do. It's so creative. I didn't even think of that for a second. But it's a great theory. I like it. Thinking like a lawyer. But that is starting to get a little bit more remote in terms of the consequences. You don't really have proof that was happening. I mean, did anybody get trampled? Not as far as I know. We didn't hear about any injuries like that. Excuse me. So I think it's the video. I think it's really the video. Need a second drink. We know from Kathy Nestor's cross-examination about one of them, she was making a big thing about nobody is directly behind in the frame when Charlie gets shot. But we also heard, this was during Agent Hull. Agent Hull is saying people were moving all over back there, kind of all the time, back and forth. And so that might be enough to get him there, because remember, it doesn't have to be the exact same time. It just has to be temporally proximate. So if people are walking back there, you don't necessarily know exactly at what microsecond the trigger is going to be pulled, and that risk is going to materialize. So if there's people within the frame, within a couple seconds, that's probably going to be good enough. If there's people within a couple feet of Charlie, that's probably going to be good enough, even if they're not directly behind him, because it could miss or it could ricochet. So I think that's going to come down to the video. As long as the video shows it's not like Charlie Kirk in complete isolation, I think he's likely to be bound over on it. And probably Agent Hull's testimony alone would be enough to do that, just based on, the people passing back and forth. The targeting enhancement, that's what the that 1102 of David Englehart was for. We haven't seen it. Well, it did get published, but it was illegible. I never did see if anybody went through and sorted it out. Probably somebody did, but I didn't see it. So that's likely going to be in that. And then the parts of the Tyler Lance Twiggs interview that we didn't get to see, we already know they're saying it goes to this. We can infer this is what it's about. But then it's also there in the messages. Had enough of his hate. Well, what hate? Well, I think that's probably what the nature of the relationship with Lance and so forth was there for, to be able to draw that inference. Oh, that hate. Yeah, that's what they meant. That's what they meant. Presence of a child. Again, that's what that video was for. Video from the audience showing kids present. As long as it's close enough in time, there's some reasonable way to infer that, like, this is pretty close in time to the shooting, even though it doesn't actually show the shooting. Doesn't seem to be time stamped. At least we didn't get testimony about that. Maybe it is, but usually that thing is, that's, if it's like somebody's cell phone video, then it's going to be in the metadata, and so somebody has to say, because it's not going to be, obviously there when you watch the video. It's not like a security camera or something. But if you can reasonably infer, because of the context, the surroundings, what you see, if we know that, Charlie, they kind of described how the event started. Charlie came out, threw the hats out, talked to the people, went on the stage, did the thing. Then probably enough. Probably enough. This one too, it's just the camera, anything. If there's a single kid on camera, like, we're probably done for the, like, actual shooting videos. If there's a kid visible on any of those, then we're probably done. Turning Point USC video may be the best one for that, because it's, the one from the rear looking out at the audience, very high definition. So there's a kid, because this one doesn't depend on Tyler knowing it. It's just literally the kid is there. What do you guys think? What do you guys think? That's where I think we're at. No question at all on the aggravated murder. The murder part, no question at all going forward. Aggravated, not as solid, but I'm confident that it will, based on Agent Hull's testimony. Victim targeting will go forward. Presence of a child aggravator for that one will go forward. Felony discharge of a firearm will go forward. Same victim, same enhancements for those ones. The obstructing on concealing the firearm, not so confident on that one. But the obstruction on the hiding the clothes, assuming that Mr. Mitchell's statement says what his, what the previous information about it says, then that one will go forward. Tampering based on directing Lance to delete incriminating text messages, that one will go forward. Tampering based on telling him to stay silent if police question you, I don't think that one goes. I'm kind of betting against that one. And then the violent offense committed in the presence of the child, that one too, it's thin. Not confident this one goes forward. Just not enough of a link of what Tyler would have known about the presence of children at the time of the crime. Because it's got that mental state requirement, and there we just didn't have a whole lot of basis to be able to reach that conclusion. That's my take on it, guys, where we're going to end up. Now, again, this is all probable cause, right? The inferences are very favorable. And it's not the same a trial, of course. You have to convince a jury beyond a reasonable doubt. And so I've gotten lots of questions about, you, Andrea, you're the defense lawyer. What are you going to do here? How are you going to defend the client? How are you going to try to present the defense? And based on just what we know, right? Because there is such a vast amount of information that we don't know. And so I can't know how that is factoring into the defense's mindset and their strategy. But what I can say is, based on what we do know, there are certain things that, they can try to poke holes in. Others are going to be much harder. But I did, when I made my list of the evidence, I kind of distinguished between, here we are at the pre-hearing, the preliminary hearing, and here's the evidence and how it's kind of going to work for the state. But here's how the defense might try to poke at it. They might try to poke at it. So start with the screwdriver on the low-C center. So we have to start with the low-C center only matters if that's the location of the shooting, right? So seems logical based on the video. But we have this empty holster that was found that actually might have had a gun in it. It really isn't even clear. The empty holster from the amphitheater. We have a gun that was found in a backpack. We have the .223 round that was found over on the other building. And then we have the whole George Zinn thing. These are all possible muddy the water about there was a shooter on the low-C center roof that caused this. How well that's going to go is really going to depend on their ability to poke holes or exclude some of the rest of this stuff. But the low-C center as like the location of the shooting, that's really, I think, what they got, is to try to create reasonable doubt. There were other things, and the state, of course, is going to say those couldn't have been the source. So the defense is going to have to come up with a theory of how these could have been the source. That could be a challenge, but that's what they're going to try to do. If it's an empty holster, doesn't have a gun in it, then you don't know the caliber. There's at least that. Probably not a .30 caliber handgun. Do they even make a handgun in .30? Yeah, I don't know. The screwdriver itself, that's innocuous. It's innocuous. A screwdriver isn't a weapon. Charlie wasn't killed with a screwdriver. It's an innocuous piece of evidence. We don't even know for sure it has anything to do with the crime. It could have been dropped by maintenance. The DNA on the screwdriver, well, we're going to try to challenge how much you can know about the DNA. DNA can persist on things where you have no idea when it got put on there. He could have given this screwdriver to Goodwill along with the towel. They both ended up in 250 miles north in Orem. But also we have, as far as the screwdriver goes, it's a mix. It's a mix, but also Lance's DNA. He's the one that was used as the eliminator, and they thought that looked real good. This was also the one that I might be able to use to just kind of call into question whether this DNA is this evidence is are they really being objective, or are they working backwards? You know, are they starting from their conclusion and then trying to make the analysis fit so that we can say it's Tyler? Why? Because they started thinking it was 3 contributors, but then took it down to 2. And lo and behold, like the statistics get stronger maybe when it's 2. At least the picture makes a lot more sense to them to say it's Lance and Tyler. It's clean. They like that. So they changed their assumption. You might do something like that. The sniper pad, do we really know it's a sniper pad? Do we really know? I mean, it's gravel, you know, it's disturbances in gravel. Maybe could have caused anything. Seems kind of a little non-specific. Does the size line up? They seemed like they were maybe going down that road. You know, you measured it. The size isn't going to comport with Tyler somehow, maybe. You're at least going to look into that to see if you can question it. The UVU footage, you're going to focus on the change of the clothes. How do can you be definitive? Can you be that sure that it's the same guy? If there's no link between the guy in the black shirt and the challenger, or anything else involving Tyler Robinson, then, you know, if you can't be real, like, how can you say lots of people look alike? I mean, even just look at Lance and Tyler. Look at Lance and Tyler. They look real similar. Can you be absolutely positive it isn't just somebody that looks kind of like Tyler? And we're on a college campus. We expect a lot of young people to be around. Seems likely there might be people there that look like him. This one, the link is gonna live or die with the cell phone data. Because, yeah, if they have GPS data that puts him on the Losi Center roof, if they have, you know, cell phone activity that corresponds with them watching, it's on one of the surveillance of the guy in black. It's written in the PC. He uses his phone at one point. They got it time stamped. They can connect that with phone activity on Tyler's phone, something he did that would make sense under those circumstances, then it's going to be really, really, really tough to wiggle out of that footage. If it's just it really looks like him, you might have a chance. It's just the chances are pretty slim that it's going to be it really looks like him. So either way, I think all they're really left with is again, he looks like Lance. Could we say for sure it isn't Lance if we try to point the finger at Lance? That's one of the avenues to explore. And I think everybody knows it at this point. Because Lance has access to his stuff. They live together. Lance could take his phone. Lance could take his car. Lance could take his clothes. Possibly. So that you'd have to have, yeah, some kind of theory that it's Lance on the camera using Tyler's phone. Where's Tyler during all this? Well, that would be the $1 million question, wouldn't it? Tyler doesn't have to testify, and the jury will be instructed. If he doesn't, you can't hold that against him. But I will just tell you from experience, the jury will want to hear Tyler's side if they get a story like that. And they're going to be very, very skeptical of a theory that is possible Possible, but he hasn't gotten on the stand and said that's what happened. They're going to be skeptical of it. And it's not going to help that Lance doesn't have, there's no strong evidentiary support for inclusion of Lance on the gun or any of the gun items. I think that's probably maybe the death knell to the blame Lance. Because how could it be Lance? He didn't clean the gun. It's got the DNA on it. This gun already has Tyler's DNA, his dad's DNA, somebody else's DNA. So it's not like he did it and then he cleaned it to get his DNA off, because that would have disturbed all the DNA. Not real plausible as an explanation. So I think that's going to be a real problem. Taking a lot of stuff, in isolation, sure, it's easy to be like, yeah, shoe print, it's non-specific, lots of people wear Converse. The audience videos, they don't show anything anybody could have shot. We'll okay, he died by homicide, by gunshot wound, but that's not, specific to who did it. The Ring doorbell, it's so dark. It's so dark. And that lady said that it was a bald guy and there were passengers and stuff like that. Weigh that against distinctive wheels that don't really look that distinctive. The Ring doorbell, no, we can throw that off. That nighttime interaction with the police department, that's kind of a tricky one. That one, I think you're left with a sort of, well, so what if he was in Orem that night? This was hours after the shooting. So what if he was up there? In isolation, maybe. But in combination with everything, well, what were you doing up there? What business did you have up there? Were you working up there? Is there anything that can corroborate you having a legitimate reason to be there? Because if not, people are going to wonder. The cop is going to be hard to explain, I think, because if they got his license and, don't know. They got his car, I believe. They got his car license, not his driver's license. If I said that, I misspoke. But did they ID him? Did they get a name? Does the guy recognize him? These are all kind of open questions, but in just the car. The very least, it puts his car there, right? Maybe that's it. His car was there. Maybe this is still consistent with the Lance did it. Because Lance maybe could have taken his car. Maybe. Lives in the same house. Surrender is also hard to explain. I think, that he knew the photos were out. People were suspecting him. Even if it wasn't him, he knew he was under suspicion. And so just go get it taken care of. Is probably the best you're going to be able to come up with that. But then the statements to the mom and the dad and the Mike Mitchell and stuff like that. Are they misremembering? Are they exaggerating? Mom recognizing him, dad thinking it's a gun. Well, that's just like your opinion, man. In isolation, maybe. In combination with all this, it's getting tricky. It's getting very, very tricky. if you're throwing Lance under the bus, then it's easy to deal with Lance. It's just everything he says is self-serving. You know, everything he says is self-serving. It's in his own interest. He's kind of covering up his own involvement. Same thing with the text messages. Could that have been somehow spoofed or something? Could Lance have both of their phones and fabricate this whole big thing? It's going to come down to the phone extractions. Where do they have both phone extractions? Where are both phones located? If the phones are 250 miles apart, then Lance is not sitting there fabricating a text conversation back and forth. Oh, you can sometimes use other devices, right, to send text messages. Maybe Tyler has like an iPad or something, and it's connected to his account. And actually, I don't even remember if Tyler had. Did Tyler have Android? I don't remember now. It's in the warrants. Either way, you know, maybe he's got another device that's linked to his account, so he could text from this other device. Well, now you have the cell records, because the cell records tell you which tower is routing this this communication. And so if you've got text messages, you know, from Lance and from Tyler going back and forth, and they're both being routed through the towers in St. George, you got a great case. But if they're on one end up there in Orem on the towers 250 miles away, it's not going to work. You're not going to be able to make that case. That's going to be a big problem. The Discord, you know, if it's from the phone, same type of deal. Same type of deal. The Discord at least would have been back in St. George. So maybe not as difficult to, you know, at least from like a cell tower kind of standpoint. Although the Discord is, Discord isn't gonna necessarily be routed that way. Yeah, guys, this is a mess. This is a very hard case to defend. This is what I've been saying. And this is just what we have from the preliminary hearing. In isolation, you might be able to poke holes and things like, sure, who doesn't have a Dremel? Lots of people have Dremels. If it was just tool marks, that's voodoo. That's voodoo. If that's the only connection, you're saying my Dremel made these engravings, that's voodoo. I can convince a jury that that's voodoo and it's bullshit. It doesn't really look good that I have engravings in my bedroom, an engraved cartridge in my bedroom, while there's also an engraved cartridge in the murder weapon. But maybe this is like a thing that people do now. I mean, Luigi allegedly did that too. Bullet that, or the casing associated with the bullet that killed Brian Johnson was engraved. Maybe that's just a fashion. The fact that I got a bunch of 30-06 ammo at my house and I don't have a 30-06 gun there, also not real helpful, but people do buy and sell guns. People lend guns to people. It's not that uncommon too that you buy bulk ammo, you know, you find a deal. So you buy a whole bunch of boxes when it's cheap. But then, you know, maybe you got rid of the gun or you loaned the gun out or something like that. So you just have like leftover ammo around. That's the problem they're facing. The location data is going to be a big problem. And Lance's DNA not being anywhere on this gun or these cartridges where other people's DNA is going to really limit their ability to point the finger at him. So the Lance did it will be easily falsifiable. It's an easily falsifiable premise because we'll be able to establish where were both of these phones. If Lance's phone is up in Orem, then we got a bigger problem anyway, right? It's not gonna be a very good witness if that's the case. Yeah, then you got a strong defense. But chances are pretty good it's not. Why would he have handed his phone over? Make him get a warrant, at the very least. Make him get a warrant. Why would you even show him the text so they would have some reason to think to look on your phone? The whole initial interview with the FBI, the volunteered interview, you just wouldn't do that. If you're clever enough to set up this whole plot where you're pretending to be him so that you can set him up, you might volunteer, but you wouldn't, volunteer to make a statement to get your story there, but you would not give them the evidence that they need to prove that you're lying. So yeah, the Lance did it. It's not going anywhere. No DNA where the other people's DNA is, and the phone location is going to be dispositive. So that's why the defense has such a hard job ahead of them. Because even taking these things piece by piece, some of them really can't be overcome. And the problem is you don't take the evidence in isolation. The jury certainly doesn't take the evidence in isolation. They look at all of it together. All of these things in combination. Not looking good for Tyler. Well, harbinger of imminent death. I once answered a death penalty jury question. Judge took unusual pains to say the only wrong answers are dishonest ones. I wonder how often people hedge because they think being difficult will get them in trouble. Yeah, or you just think it'll make you look bad. I think there's a lot of that. We self-censor. This is a formal environment. I think it's kind of natural for people to wonder, how really confidential is this? Yeah, will I get in trouble if I say things that maybe, are honest, but just maybe people wouldn't like to hear? I think that definitely plays a big role. The self-censoring, no question. Ginger Puff 764. What a week. Much appreciation to you, Andrea. So grateful for your work on this for all of us. Well, I'm just glad to have had you all with me for the ride. And it will continue. We'll see where it goes. To Truth for Liberty. Graphic content warning is okay, but should show all. The First Amendment allows citizens viewing a public trial to close their eyes and plug their ears anytime they want. Yeah, that's true. It's kinda, I have to come back to the kinda because I didn't want to see Charlie get shot. I didn't want to see that on September the 10th, and it was there. I opened Twitter and it was there. And I lots of people had that experience. It is a little bit of a different era. I do appreciate that. Maybe that wouldn't happen with the trial because it's not happening in real time. We're talking about something that's a past event. It was obviously a big deal with Charlie because it's like real time. This just happened. Here it is. I'm not against it being available. I wish there was some kind of compromise, Fine, don't show it on the TV. I get that, but put it in a court Dropbox or something like that, the exhibits, for people who want them to be able to go find them. Have like a website like the Koberger thing did, which, has a massive amount of editing, redacting, and so forth, stuff that's remains sealed in that case as well. Although it's like still dribbles out. Something like that, maybe, so that it's just, I don't know, less likely to have that occurrence like happened on September 10th. But yeah, I mean, if my concern with these situations is really primarily the family. And if they think we should see it or we have the right to see it, then I would honor that. And if they were of the opinion, I don't think this should be out there in public, personally, I would honor that too. It's not a maximalist position on that part. But I do get it. I would at least try to honor it as much as I could. Because it's just a very painful thing to be out there. It's just it never goes away. You can never kind of put it behind and be done. Just knowing it's always out there. MELC gifted a membership. Thank you so much. Thanks for that. MELC, do you think the judge saw the ripe video? We saw it all live, so we have to call Elon. I don't know. I don't think he did. I think he made the comment that he hadn't seen it. Pretty sure he made a comment that he hadn't seen it. So all the video evidence that he saw, it was new to him. Kind of recall that offhand comment. I could be wrong, but I do vaguely remember that. Or are you talking about, oh, the rip? You're talking about the ripped. That's what you mean. You're not talking about the video, Charlie. You're talking about the screenshot of the of the note that got out. Yeah, I'm confident that's what Mr. Novak handed up to him is a printout of that screenshot showing it's on Twitter. Somebody tweeted it, whatever. I mean, probably lots of people did. What can Elon do for us with that one, or for authentication purposes? I mean, it's going to get out there. Things like that happen. It's going to get out there. No question. To Truth for Liberty. Using assumptions, a DNA finding is a hypothetical. Yeah, it kind of is. It kind of is. It's assuming this hypothetical. How likely is it relative to what is kind of like the null hypothetical? If these are the only possibilities, and that is the thing. I mean, they do try to structure it that way, right? That these are the only two possibilities: a universe where Tyler Robinson is included in the sample, and a universe where he's not. It's just the problem is that because it's not based in real population genetics, they can't really do that. But it kind of is as close to it as they can get. But it really is. It's assume these hypotheticals. So if you do, what's their relative likelihood? Emil C. I'm a conspiracy guy. Why always engrave things and kill people? Sounds like other things. Well, like I said, it happened in New York. Happened in New York. I'm sure it's happened on other occasions too. There just happened to be, high profile instances of that happening. I mean, if the suggestion, like, is it planted? Is it planted? We don't have any evidence that it was planted. If we develop evidence that it's planted, then we would consider that. But as we sit right now, I'm not seeing a basis for any kind of evidentiary argument that it was planted. So suggesting that as a possibility, yeah, it doesn't violate the rules of physics. Somebody could have planted it, but does that make it plausible? Does that make it a thing that I think is a reasonable doubt in the case? Me personally, no. And I think I'd be able to talk a jury into seeing it that way. Michigan Farm Boy. We're going to give you a huge number that we can't actually explain in a way that a layperson can understand the significance of, other than it is immensely large, and you're giving me the impression that bad man did it. That's literally why they love the likelihood ratios. If it were a population statistic, it would be much lower, right? Because it would be based on the actual population of the planet. So it would max out at whatever we're at now, 6 billion, 6.5 billion. I'm not even sure what the world population is like right this second. And so you'd be able to, it'd be fairly easy because you'd be able to relate it always to that. If it's 1 in 6.5 billion, then you're the only one. If it's 1 in 8,000, well, now you can do the math. And so how many people on the planet could share that profile? It would be a lot more practical. But that would also mean that in the absence of that really, really strong statistic, the 1 in 6.5 billion, then defense me over here is always going to be able to point to it and be like, do the math. That means there's other people. How many other people in the world that could have that profile? That's why they like the likelihood ratios, because they are hard to understand and they sound so astronomical and they're so easy to confuse with the population statistic. And many, many attorneys, McBride seems like he gets this stuff, isn't going there. Wonderful. But many, many attorneys do present it as a population statistic. Many defense lawyers don't know better to challenge it. Many judges don't know better either. And so then the jury will hear, oh my gosh, a 1 in 8 octillion chance it's somebody else. And that's not what it means at all. That's why they love that population statistic, or that likelihood ratio. Harbinger of imminent death. How much does court acknowledge non-lawyer confidentiality, medical, religious, journalistic, etc.? How protected are statements to these confidence? Pretty strong at the state level, at least. Federal does not really have a journalist privilege. Journalist privilege is all the state creation, but I'm pretty sure last time I looked, every state now has a journalist privilege. I remember that because Idaho was one of the last ones to adopt it. And Idaho adopted it right around the same time that they had that leak, the gag order violation that went into the Dateline special that was played like shortly before the trial. And everybody was kind of pissed about it. We're going to appoint a special prosecutor and we're going to get the bottom of this. No, you freaking aren't, because in like 6 weeks, this new law is going to take into effect, is going to come into effect. And you are going to lose your ability to subpoena, warrant, whatever, the Dateline people and compel them to tell you under penalty of going to jail. And if you don't do that, you're not going to find out. And lo and behold, here it is all this time later, nobody's found out. I'm not necessarily a fan of the journalist reporter shield. Kind of for that reason. And just because I've seen too much of, the defamation laundering I talk about. They put it in the court filing so that the dirty journalists, and it's like a whole little plot thing to do. So journalist, state level, yes. Federal, not so much. Yes, priest penitent privilege, common law privilege. That one is pretty strong. Not sure, like most of the privileges have an exception for if you know somebody is like going to go out and harm somebody else, you do have a duty to disclose that. That's the same thing with the attorneys as well. If I know my client's gonna go home and shoot his wife, I gotta let the police know. I can't keep that privileged. But that's the exceptions are really limited. These are some of the most powerful privileges that we have. Same thing with the medical. The medical, where the scope usually comes in, is with your physician. Really, no question. The limit is make sure the statement is made for medical purposes, right? If you go in and you threaten your doctor, it doesn't relate to your treatment. That's not going to be privileged. But also, with all of like kind of the different providers we have now and different like certifications and stuff like that, not every state recognizes a therapist privilege. And if they do you have to be a licensed psychologist? Is it okay for you to be a talk therapist? Do you need any specific qualifications? The kind of further you get from something that is, formally licensed and certified by the state, the more remote the likelihood that there's going to be a privilege attached to that. But barring that, yes, courts absolutely protect these various privileges. Kyle Wilbur, 4318. As a longtime hunter here, why didn't defense not have a weapon expert poke holes the FMJ round? It's like they don't want to touch the fact the bullet didn't go through. Well, we don't know what they've done in the background. Doesn't look like it's a full metal jacket round. It does look like a soft tip round. But we don't have great photos. They have better photos than we do. The best answer I can give you on this one, as far as not challenging it, is because one, they have the autopsy. Like, we know it didn't go through. They know it didn't go through. So, the question is why. They have this caliber. So they could have maybe gotten like one of these retired experts from the ATF or something like that to see if they agree with the caliber that was assigned to that jacket. She gave the range of it was like just above the threshold for a 7mm ammunition up to the 30 caliber. I forget, it was like 0.286 up to 0.308 or something like that. I forget what exactly her range was, but you could potentially, play with that conclusion that it was 30 caliber. I mean, they have to get somebody that will say it, but questionable whether that would work at this process anyway. Like, this wouldn't be the time to do that, because it doesn't really matter what the defense says at the preliminary hearing. It doesn't undermine the state's position that it is a 30-06. It just argues with it. And then you have a battle of the experts, and somebody decides who they think is right. And that somebody in this system is the jury. So they wouldn't have anything to gain from doing that. They're not precluded from doing that at trial. But that's why I think they wouldn't do that at this stage. This isn't the time for that. Two Truth for Liberty. Graf did boil the frog, slowly restrict public access. I didn't think about that. Have we been the frog this whole time? I didn't think about the possibility that we've been the frog the whole time. I did notice it was getting a little uncomfortable. Maybe getting a little, I was certainly getting a bit heated. I'm sure I wasn't the only one. Matthew McClellan. Eyeballs at Burt CV. There's a lot of reduction mitigation success. The play behind the briefing request, room here for similar to their past successes. I have said, I don't know that I've said it a lot, but I've, certainly thought, I know I've said it. This is likely a mitigation case for the defense, and has been from day one. You get the probable cause, you read it, you're like, you can tell, is this going to be an easy case to fight? Is this going to be a hard case to fight? Are there lots of holes in this to work with? Am I going to have to blow a lot of things out of the water to have a good chance at actual innocence? And this is not an easy case, even from just the probable cause. So it's kind of always, it's a mitigation case. And yeah, he's good at it. Novak's really good at it. Novak's good at just the attrition. Wrote that piece on it. The battle of attrition. That just fight and fight and fight and fight and fight and fight and fight every little thing. And even if he doesn't win, it doesn't matter. He just wears them down to the point that they'll just be like, fine, take it off the table. Even though your guy is already doing life without parole, and that means he gets effectively no additional punishment. Just sick of fighting it. There's just too much of a chance he's going to come up with something that might go somewhere. The guy is persistent, extremely persistent. This has always been a mitigation case because that's where they have the most room to really achieve something for him. They have a lot of good mitigation evidence. I mean, information just already. That statement of Lance alone, he cried, said he wished he hadn't done it. Fact he turned himself in. The fact the defense is already highlighting that so much, voluntarily surrendered. He's not your 3-strike prison jailbird who's, already committed a whole bunch of violent crime and now has killed a corrections officer, Pretty good indication of might be irredeemable. He doesn't have that at all. He was on seemingly a good path. He may have a sympathetic argument vis-a-vis his personal preferences and the difficulty reconciling those with his family and the community that he's in and so forth. I mean, as mitigation goes, just what we know publicly. I think there's a pretty good case. Is this the worst of the worst? I mean, I can think of some more egregious stuff, I feel like, just kind of, without really even having to sort of look too far. Is this worse than Nick Reiner? Obviously, other issues going on with that one, but this individual, this crime, are those things? Is that worse than Nick Reiner? It's a tough call, but that's really the key. Is the death penalty is supposed to be reserved for the worst of the worst, and so where does he fall on that? Giselle D wanted to say thank you for all that Andrea and the mods do. The best coverage and analysis on YouTube streets. Well, thank you for that. I am so grateful for the mods and everything they do to help. They're just always here. So dependable. All the contributions. CH with the timestamps. I'm always overwhelmed at everything they do to help get the word out and stuff. Amy LC, they are saying soft tipped now. That is what it looked like because you can tell the tip is blunt. The tip is blunt. It could be a hollow point full metal jacket, possibly. But I'm not sure. I mean, I'm not sure if Remington even makes a round that would look like that. That's a full metal jacket hollow point. But it's the yeah. You don't see, it's like not the visible soft tip, but it's got the blunted tip. And so I know Phoenix ammo is out there, it's saying it's the core locked. Does look quite a bit like the core locked. We of course didn't get that laid out here, but if it is, then Yeah, it's a soft point. And this was, it's kind of to be expected, right? That's the prediction. That's the prediction. Why? Because soft point rifle ammunition, that's what contributes to your fragmentation, your lead snowstorm, those types of things. And these are all extreme. That's very well known forensic. It's like so well known forensically that they can identify. They can take your X-ray and be like, oh, that guy was shot with a high caliber with a rifle, shot with a rifle with a soft point ammo. It does that, so predictably. So we'll see. We'll see. Didn't get definitive information about that in court, but at some point it seems likely that we will. Kyle Wilbur, 4318. Confusing part, he pulled this off and then made a confession. Same person pulled this off, could have got away with it, but chose not to. Well, I think he realized the walls were closing in. I'm not sure that he would have pulled it off. I really don't. I mean, the getting the photo out was the one thing, but it would be a matter of time because they would do the geofence. They have almost certainly done the geofence. We're not hearing about it. Maybe we will or, may not by trial. They may be cautious with things like that because if they don't need it, we didn't get a definitive Supreme Court ruling in Chatry about whether it's generally, okay constitutionally to do these geofence warrants. So it's still a little bit of an open question. You still got the Fifth Circuit out there that said, no, this isn't allowed. It's a general warrant lacking suspicion for, just all kinds of people just based on where they were, proximity to a crime. It's kind of the antithesis of the particularity requirement of the search warrant. So they would have had the geofence. How precise they could be with that, if they knew it was the low-C center roof, could we narrow it to the low-C center? Yeah, probably. And then you just start going through your process of identifying and trying to rule out, trying to see what you can, associate with this information. That would be super risky if they did that, honestly. The way that they've, sort of kept it restricted, cautious is the two-step where they get the dump of all of the data, but they don't actually look at it until they have an individual suspect to connect with one of the devices, and then they unmask that one. So then if their view is, if I don't unmask everybody, then there's not really a privacy violation, and that might work. That might work. That's what the Fourth Circuit in Chatry, now that it got sent back down, that's basically what they're going to have to decide. Does that cure any problem? Much bigger problem if you just dump the data and look unmask them all and look at everybody, but not technically illegal yet to do that. Just really challenging. So, but of course we know that law enforcement will then just go and parallel construct the investigation anyway, right? Such a cynic. I'm such a cynic. I don't know that he would have pulled it off. They would have gotten tips. Right? Seems likely they would have gotten tips if as soon as the photos are out, if the parents are already thinking it's him, if the gun is thinking, the dad is thinking it's the gun. Seems like it was a matter of time till parents would have gone to the police, if nothing else. They would have tracked it to the car, and at least from what I'm hearing about the video, as you can see it in court compared to how we see it at home, distorted through, lenses stacked on each other and stuff. My understanding is it's quite clear, and you can see the driver's, the license plate and everything. And if that's the case, then they're finding him very quickly. So I don't think it would have been pulled off. Alleganews. Do we know if this college offers dual enrollment for high school 11th, 12th grade? If so, presence of minors. Good question. I'm not sure. Wonder what they consider a child. Yeah, for the violent offense committed in the presence of a child, the aggravating factor, they don't define it. The other one, the one that was the specific count, violent offense committed in the presence of a child, that one has to be younger than 14. So that would not get us there for that particular count to have 11th and 12th graders. But for purposes of committing the crime in the presence of a child, minor probably counts. I don't know if they do or not. It wouldn't surprise me. The thing about Utah is like so college heavy, it's insane. There's like a college on every corner. Mormons are really into education. Really into education. So many education institutions and stuff. Wouldn't surprise me at all, but I don't know one way or the other. Harbinger of imminent death. If you found yourself suddenly needing a defense lawyer, how would you balance getting any lawyer ASAP versus making sure you get a good one for the long one? Oh boy, that is the $1 million question. Because I assume you need a lawyer right now ASAP and you've never needed a lawyer before and you don't know lawyers. Number one, call a lawyer that you know. That's like the best step. Call a lawyer that you know and try to get a recommendation. Because just, reading the AVO reviews and stuff like that, probably not going to get you where you want to go. Like marketing materials, Google reviews, I guess stuff like that isn't bad if you have actual client feedback. It's just you don't necessarily know for sure that they're legitimate. Word of mouth is kind of, by and large, really still the best way to get a lawyer. So yeah, I would say if you know one, call them. If you know anybody who's gotten a lawyer, call them. If you can't do any of these things, do the best you can to, pick what seems like the most qualified person online. Always helps if you can shop around, try, call a few people, see who you get a good impression from. Who do I vibe with? Who seems like, smart? Who am I getting a good read from? That kind of thing. But possibly, if it's like I need it right now, don't rule out the possibility of changing. It's not ideal. But sunk cost can be a real significant thing with lawyers. You got a really bad one and they're a bad one, but you stick with them because you've paid them a bunch of money and they've gone so far down this road, and you keep hoping they're just going to turn it around and finally listen to you, finally get stuff done right, finally be diligent, finally call you back. And it doesn't happen, and then just the longer you go, the more stuck you are in that situation. So it's never ideal to change lawyers, but if things are off, do not hesitate. If you suspect you may need to jump ship, pull the trigger. So much better to do it sooner than later. Best advice I can give you on that. Free men die free. Tyler is up against the same people who gave Epstein a sweetheart deal. Prosecution isn't interested in the scene being paved over, glass in the SUV, or any evidence which counters the FBI findings. Well, this is the SBI's investigation. Remember that. There are 28 law enforcement agencies based on like a March disclosure that have contributed discovery for this investigation. And the feds are two of those. So the overwhelming majority of this investigation is being done by the state. It's being managed by the state. You have no idea what their interest is in any of these things. You have no idea what they've done. You have no idea if any of this is even legit. You have no idea what like provenance of glass in the SUV is. If there's anything to know, again, the defense knows it. And they have every incentive to bring it out. Why do you think they Epsteined him? Why do you think he got Epsteined? Because he had the incentive. There was that hint, that little hint from, what was his name? Agent Davis, that little drop in. He's trained in the 3D crime scene scanning. Suspect, highly, highly possible that that's been done. They don't care about the scene being paved over because there's nothing of evidentiary value there. That's not where the shooter was. That's not where that evidence is. And there's not really much dispute about Charlie dying, where it happened. The material evidence relating to Charlie's death is going to be from his autopsy. And so the time and the, just probativeness of this particular area is not going to be significant. It's not going to take them a whole lot of time to do the UV light and do the phallopthene testing, like just whatever stuff they're going to do, because there's not a whole lot probative there. Photograph it. Look at anything suspicious. Collect anything that seems out of place. After that, there's no more value to them. So, glass in the SUV, nobody cares. If Charlie took a 30-06 in the neck, as everybody saw, the blood, I knew he's not surviving that. It would take an absolute miracle. Medical examiner has determined it was the gunshot wound that was the cause of death, not anything that happened in the SUV. So suggesting they don't care about this is just ignoring the reasons why they don't. You have no idea what they've done with any of this information, how they vetted any of it. And, I just gave you a long list of like all the levels of corroboration and stuff like that and where it came from. So if you think they're not interested in countering things like the FBI's DNA, the defense is, and that's very easy to do. So that's a wait and see what happens. Free men die free. I'm convinced Lance secured the rifle for the FBI. Police searched the area and didn't find the rifle. FBI shows up and magically a rifle appears. It was under the bush. It was hard to see. We don't have a lot of details at this point about, who searched exactly where and so forth. Seems like they found it pretty quickly. What, about 6 p.m. or so? After they had found the security footage and their, that's what Jen Famuina testified about. If Lance secured the rifle for the FBI, then Lance's phone will put him in the area. If Lance's phone puts him in the area, we got a whole different situation. But if Lance's phone puts him in the area, we're going to hear about that from the defense. No question about it. The Defense Rests is a YouTube member now. Welcome. Welcome to the channel. Good to see you here. Emil C. Sorry, I'm a former medic. Want to hear about my scars? I do actually. I love people's war stories. I really do. There was a period of time, every lawyer goes through a period of time where they like hate their job and they fantasize about, what are they going to do or whatever. Cause you got you got shitty cases, or you're dealing with a particularly obnoxious OC or something like that, opposing counsel. Anyway, there was a period of time where I did imagine just like running away and going to the EMT training, or the paramedic, doing that kind of thing. I was like, it sounds like it would be so just material, like you're doing such a materially good thing, treating people. But obviously I never did that. And as it turns out, my father-in-law is a retired ER doc. And at one point I talked to him about that. I mentioned that to him, and he was like, "It's such a good thing that you didn't. Like, you would not be good at it, because Andrea, you'd be in the ambulance and you would be doing this amazing job, and you'd have this person like just ready to go, made a massive difference, and then you would get them to the hospital, and then you have to hand them over to the doctor, and the doctor is going to immediately mess it up and you're going to be furious because there's nothing you can do about it." And I'm like, ooh, I would hate that. I would hate that. That would be really bad. So I'd love to hear about your war stories, frankly. Anytime you want to share them, I'm all ears. Potbelly76. Why isn't it a problem that Lance said Tyler Robinson etched the bullets a month prior for family hunting, but Tyler Robinson only planned a week, and Charlie Kirk's events wasn't announced until 8/27? He didn't say Tyler etched the bullets a month before. He didn't know when Tyler had etched the bullets. And so they offered him the time frames to help him narrow it down. Was it a year ago? Oh no, it wasn't that long ago. It was no more than a month ago, is what Lance said. It was no more than a month ago. So he didn't specifically remember. There's no inconsistency with that. Two Truth for Liberty. Only one little fragment of jacket is odd. I mean, it doesn't look that little to me, but I don't know how much of it would be missing. I will say, if there's lead snowstorm, if that's one of the things that's, present, a conclusion from the autopsy, in the autopsy report, then it's not uncommon that, like, you're talking about a massive amount of energy dump and energy transfer. And stuff like literally, what's the word I'm looking for here? Not dissolve, but like, it's getting late. It's Friday night. It's been a long week. My words are gone. I know you know the word I'm looking for. Anyway, because it's not that uncommon. You're not going to be able to, or there's so much energy being transferred, and there's so much instability with the projectile and everything. A lot of times it will break up into such small pieces that you can't recover them. It's like dust. I mean, it might as well be like dust. That is what, like, if you haven't done it, just Google lead snowstorm and get an image, and you'll see the X-rays. And I mean, it is like you will get dust. It's not uncommon to recover, the biggest pieces that can be recovered, but they're not going to dig in and like try to recover every single little grain of something that's in there. So I would, like to see the big picture. I would like to see, what are we working with here? Can that be accounted for? Because if it's just fragmented into a few big pieces, then yes, you'd expect that you'd be able to recover all the pieces, and then you would wonder why you didn't. And then you would be wondering about that suggestion that there was additional lead fragments that aren't accounted for. Is there also additional bullet jacket that's not accounted for? You might wonder about that. That's on my radar. I'm not going to forget that, because that's not good. If that happened, that's not good. And they have to have an explanation for that, or that looks real bad. Didn't get that level of depth here. Defense didn't raise anything relating to that. But this is still, again, preliminary. So not impossible that we could hear it in trial. Poor Jeff is like back in the private chat trying to feed me the words. Disintegrate is kind of what I was going for. Gifted one Andrea Burkhart membership. Thank you so much, Emil C. I really do appreciate that. Trump's SC gal. Thank you, Andrea, for all your insight. After listening to the preliminary hearing all week, what questions do you have or would you have asked Lance if you had the opportunity? You know, I'd want to go kind of back through his interview. I do remember there were a couple things that I thought like I would have liked that to be followed up on. Let me see if I can find that in my notes. It was pretty early in day 4, right? Okay, here we go. Did Tyler work outside of St. George? You know, how far, like what was his range that he would go to work? I would like to get something like that as far as a kind of normal pattern so that we would know if going to Orem is an unusual thing or not. Maybe a little bit more about the hunting too, like just to get a little bit of background on what is his experience with the knowledge of guns. Is he out shooting at the range a lot? Does he do a lot of hunting trips? Is this a kind of new thing that he was going to do? Kind of maybe would have followed up on the engraving the bullets, you know? You knew he was doing that. Asked about the Dremel. Told him not to blow up the bullet in the house. What were you thinking about that? I would have liked a little more follow-up about that. Did that seem strange to you? Did it cross your mind to ask him? It just seems like a weird thing to treat like it's normal. I'm going hunting, so I need to engrave bullets. He didn't elaborate. You didn't ask. Would have liked to have maybe gotten a little bit more about that. Why did you take the picture of the note? Just for curiosity, just kind of. What was your thought process that led you to photograph this note? Why did you do that? What were you thinking? Not that it's wrong, not that it's right, just what was your thought process? Did you guys ever use each other's phone? Did you ever use his car? This is like good rule out stuff, right? They know his car is up there and they know his phone is up there. Get Lance on record. If I'm an investigator, I want to know from Lance who Tyler's closest friend group is. You know, does he have real life friends? Is it mostly online people? Who am I going to be talking to kind of get to know Tyler? His reaction. You know, I might push him a little bit on these text messages. You know, Tyler's telling you this thing, and you kind of like initially seem surprised, but then you don't seem really alarmed. What was going through your mind? What were you thinking? Did it occur to you to report this? Why did you decide not to? You didn't seem disturbed at the idea that he had shot and killed Charlie Kirk. I'm just going to say, most of the time, finding out that your person you're in a romantic relationship with has murdered somebody is probably going to alarm people. You weren't worried about being at the house. You weren't scared of him. Were you scared of him? Any reason that might have seemed not out of character for him? Or I question this. I definitely question the minimizing about the politics. Because the explanation that comes foremost to my mind, the reason why Lance isn't particularly concerned about any of this is because he doesn't care that Charlie was shot. But, he seems to be kind of like minimizing. He's not really into politics anyway. Well, did you know who Charlie Kirk was? Were you familiar with what Charlie Kirk did? Were you familiar with his viewpoints? Because you seem kind of unsurprised or unbothered that Tyler is telling you that he just murdered him. And that seems kind of unusual. Those are the main things I can really think of off the top of my head. I'm sure that there is a lot more. I mean, there's a lot. There's a lot to ask Lance that you'd want to know from him. Kyle Wilbur, 4318. You and Baron Coleman would be a great live show. I don't suspect that's happening anytime soon. But thank you for the compliment. Do appreciate that. Oh, in the beginning, Charlie didn't care about politics. Yeah, see, I really didn't know that much about Charlie. I wasn't, I knew who he was. I knew he was like a political organizer, really was kind of all that I knew. Political organizer for the right, influential with the youth. That's probably I'd say the main thing I knew about him is it was like this thing where young kids are suddenly, particularly I think young men are suddenly kind of becoming more conservative because they've been, they're inspired and influenced by Charlie Kirk. But I really didn't listen to him, didn't, watch his things, didn't know that much about him. Just know he started very young in politics. He was originally just open markets. Well, look where it took him. Look where it took him. Oh, all right, guys. What do you think? Feel like we got a pretty good view about where this case is going to go in terms of the process, next steps, and all that. Got my doubts about some of these charges, but definitely I think the main ones. No problem. The standard has been met. Different situation, of course, when we get to trial, but there's a lot, of course, we haven't seen, a lot more that can be done and all of that. But just even with what we have here, it's a tough job for the defense. Not a whole lot of good options to blow holes in everything that they're going to need to blow holes in to convince a jury, have some doubt that it was him. Emil C., I'm trying to become a better human, pushing towards Christian. Never heard him say a bad thing about other people, just debated personally. Yeah, like I said, I don't know him. I didn't really watch him. I wouldn't say I had the impression of him as being a particularly bad guy, you know, uh, in that the thing I don't like about the politics is the partisanship. It's the team sport thing. That's what I don't like about it. And then when it turns into mudslinging, you know, the fascist this and the libtard that, like it's just, and that's all very, it's just so thought terminating and so elementary school playground. I never got the sense that Charlie was one of those people. And so to that extent, you know, I appreciate that kind of politics. I really do. Keeping it about the issues. It seems like so naive and old school now to be like, but what about the policies? Can we talk about the policy? Like it's just we're past the point anybody caring about the policies. It's just this you know, realpolitik power dynamic that goes on, power struggle. But I would have to say, you know, I agree with this, and I think this was a common theme. That I think this is why people, you know, Charlie was as influential as he was, is because I think he inspired a lot of people, a lot of young people, and that's not a bad thing. The Purnells, 1799, as a defense lawyer, if you had clear evidence the state had made up evidence, what are the odds you'd save it for the trial? X wants to know. If the state has fabricated evidence, this is fraud on the court, and this is a problem on so many levels. We have seen them try to make tiny little issues with the camera into due process issues, but a clear and unequivocal due process issue is the state presenting fraudulent evidence in a criminal proceeding. This is a due process violation on every level. Infecting the process with fraud, getting a search warrant fraudulently, this is a Frank's problem. Getting discovery, you know, false discovery, withholding false stuff, this is a Brady problem. What else do we have? Oh yeah, the just knowingly presenting the false evidence in and of itself is a NAPUI problem. Like at all levels, courts have found, all places in the process, states presenting fraudulent evidence, this is a fundamental due process violation. And that's the kind of thing that gets your case thrown out, that gets your death penalty taken off the table, and gonna have a little bit of an impact on the public perception of the case, don't you think? So no, there's absolutely no way you hold this card. Why are you sitting here? We just watched a week of the defense trying to play 2-7 offsuit. If you are sitting on aces in the hole, you freaking play them. There's no saving something like that for trial, because it is ammunition for you in so many ways and on so many levels, and the investigative doors that is going to open up for you to be able to inquire into that and follow up on that and find more impeachment because of that. And the idea that if you whisper it at all, you know, you're going to blow your hand or something, you're just not using the best thing that you have. And you are cutting yourself short of all of the benefits that you could get from using it. What's the advantage that you get from sitting on it? That's kind of like surprise. There's no surprise, right? Internet sleuths figured out the fraud because the defense has left tea leaves in their filings, right? It's that obvious, that easy to figure out, then there's no surprise. Pin people down on their story. They're already pinned down by their reports. You already get to impeach police on their story by their reports. Okay, maybe you need to develop more. I don't see the trade-off between I hold this so that at a future trial I can impeach one or two witnesses out of probably like 100 that the state's going to call, and like hope that the jury buys it. To me, this makes no strategic sense, no logical sense. I do not see the upside at all. You absolutely play this card. You play it now. This is a due process violation. This warrants at a minimum the death penalty being taken off the table. And by the way, if this is fraud, and I can prove this is fraud, this is the type of thing they've been talking about as far as, does this fundamentally undercut your evidence? This is not a weighing issue. This is, if I can't use this evidence, do I still have probable cause? Like, it actually kind of goes to the whole purpose of this hearing. Unlike arguing around the edges of DNA statistics and then impeaching tool marks on like the thing you really shouldn't have impeached it on. I don't know why they impeached the tool mark lady on the inconclusive bullet jacket instead of the Dremel. The Dremel that actually like provided the link. That's such voodoo. Such voodoo. I mean, think about this. How it works. You got to have your sample to compare. With the firearms, real straightforward, very standard method. You fire it into the water tank, right? You have the gun. You just create another shell casing. You do that mechanism from the gun. Get those marks on that new shell casing, that bullet, whatever. You shoot it into the water tank, and then you have the thing to compare it to. How do you create a comparison sample from a Dremel? How do you do that? Is it standardized? Can't imagine it is. Are you using your own bare hand? Then it seems like there's human error. Like, just conceivably, how are you doing this? It's like the stuff is bad enough with the firearms, the voodoo, and then you turn it into something like this drill bit caused this mark. Oh my Lord, I can't take it sometimes with the pseudoscience. So I mean, they're doing that when they have fraud in their pocket. Really? Really? Come on. Come on. There's nothing defense lawyers like more than calling out corrupt cops and prosecutors, rubbing their noses in it, waving that flag high and wide. Because those people shouldn't have power. The longer that they're in power, the more people are going to be abused by their abuses of power. Not me. Not me. Emil C., I was an atheist. It's a common path. So was Saint Augustine, who is not joining us here. That's who Gus is named after. The cats are all named after saints. That was our theme, except for Lilith. Except for Lilith, she is the demon. But the rest of them are saints. Kyle Wilbur, 4318. Do you believe you and Barron would get along on a live? I'm not sure that we would really see eye to eye, and I question the ability to have a conversation that would be fruitful. That's really all I'm going to say about that. I don't know Barron. I have no personal feelings about Barron. I don't watch Barron. Honestly, I'm not interested in Barron. We have very different focuses. I look at the case and the evidence and the legal practice. I spent 20 years trying criminal cases and appealing criminal cases. That's what I'm interested in. He's interested in other stuff. That's fine. That's fine. Whatever you're interested in, watch that. But I just don't think we have enough common ground for there to really be a likely fruitful conversation. Harbinger of imminent death. Prosecutors listen to victims' families. Have the Kirks given any indication how they would feel about a plea offer? Life without parole is nothing to sneeze at. If they have, I haven't seen it. I haven't seen it anywhere. They do listen, but it is ultimately the prosecutor's call. So it may or may not make any difference anyway, but I really don't know if they've said. A lot of trade-offs, I think we can tell from the position that the Kirk family has taken in court and their statements about this and stuff like that, the things they filed, that they want us to see. They want us to see, they want themselves to see the evidence of what happened to Charlie. They want the world to know what happened to Charlie. And that's one of the trade-offs with a plea deal. Yeah, you can do a big dump of the evidence or whatever. And there almost certainly would be at some point, if not, a total release of all evidence, because, plenty of things still remain sealed, but at least more evidence would come out under grandma after a conviction, a judgment, time to appeal expire probably. Then, your investigative privilege to not reveal information is less. It's not really a privilege. I shouldn't have called it that, but it's just, the case is over. You don't have really you're not jeopardizing anything to publicize it. So you're more likely to get like the police files and things like that from public records activity. But it's not the same. It's nowhere near the same as having it all vetted in open court in a trial. So I'm not entirely sure that they would really even want that. I don't know their feelings about death, about the death penalty. Kyle Wilbur. Doesn't it scream Patsy if it's that obvious? I've lost track of what's obvious at this point. This is obvious. If you're saying like the case is really obvious, yes, it is. Go down to your criminal court. I ask you this favor. Go down to your criminal court. Pick a day where there's a docket. Okay, just a run-of-the-mill criminal docket. It doesn't matter. It's the arraignment docket. It's the criminal law in motion docket. First appearance docket is a really good one. First appearance docket is a good one because often they will be reading the probable cause statements on the record. I want you to have a good sample of criminal cases to get a sense of what's normal in terms of how obvious they are before it starts to become suspicious. Like before, you get too set in your idea about what's suspicious and what isn't. Because my view, well over, 1,000 cases of my own, plus all of the other cases that I've heard going on in court while I'm there handling my own cases. I got a big sample size. And most of them are pretty obvious. Most of them are pretty obvious. Most people are not that smart about not getting caught. extremely small percentage of criminal masterminds. Most of the time it is obvious. So no, I can't say that's a red flag, because from my perspective, watching the cases go through, that's normal. That's normal, because people are dumbasses. They take their phones with them when they commit their crimes. They talk to people about what they do. They get caught on camera everywhere. They do insanely stupid things. And it's often incredibly obvious. So that's what I would ask, is if it's based on your perception of like how this fits into the, is this an outlier or something? Go look at some. Go watch some court. Go watch some court in your local courthouse. It's a great thing to do anyway. It's a great thing to learn. See how the system is working. See who the personalities are in your community. See who's committing what crimes. It really is a good thing to know, and there's just not a lot of people that do it. I always like to encourage that, to get to know your local court. We have, prosecutors are typically elected in every county. Do you know what makes a good prosecutor and doesn't? Do you know if your local prosecutor is really doing a good job? How much do you know about it? If you live in places where judges are elected, I live where judges are elected. Every freaking election cycle, when there's a judge on the ballot, I got all kinds of people calling me, Andrea, I don't know who to vote for. Nobody knows how to vote for judges. They're not partisan elections in Washington. So you can't just party line vote the judge. So it'll help you. It'll help you with this question, I think, and it will also just help you be a better citizen, to know a little bit more about what court is like and what's normal and how it works. Michigan Farm Boy. The handheld nature of the Dremel introduces so much variability. How do you match that? Unless there is a chip or burr on the tool so distinct that it jumps out, and even that is iffy. Yeah, I mean, again, you're presuming these things make it unique. Does that make it rare? Seems pretty common to me for drill bits to wear. I mean, the idea behind it is that it's so unique that you'll be able to tell, but that's the whole point. We don't really know that. We just don't really know that. The handheld nature of the Dremel tool. Definitely going to be a big factor. I'm trying to conceive of how do you even, like, it's just to create your sample, your comparison sample. How are you not just introducing arbitrariness with how you create your sample and choose to compare it? It just, yeah, I would have loved to have heard that. I would have loved to have heard that. And the whole problem. The bullet jacket isn't a problem at this point, right? It's inconclusive. It's not harmful to the defense. You don't really have to worry about that so much. It's inconclusive. It's just the caliber that's consistent, but there's a lot of 30 caliber guns out there. You can't even say definitively it's 30-06. It could be 308. It could be, be other things. 7.62. The challenge the defense is really going to have with this particular issue is that it's not going to keep this evidence out entirely. Extremely unlikely that it's going to keep this evidence out entirely. I mean, because even like, to the extent, yeah, we had Maryland Supreme Court, State versus Abrukwa, recognize. This has been some junk science for a long time. We're going to put some limits on it. But they didn't throw it out entirely. They said we're going to limit what you can claim. We're going to allow you to make consistency claims, and that's it. That's where we draw the line. It's like the source attribution problem. You don't get to say this gun created it to the exclusion of all other guns. You just get to say it's consistent. These make consistent marks. So that seems to be kind of the best that the defense is likely going to be able to hope for with this tool mark stuff. Anyway, even if they can convince the judge what they kind of want to do is unreliable, unscientific, so you have to keep it within the limits of what it can do. But this, like, that's the firearm that's like so standardized, and it's just the same process every time. A Dremel tool, I can't imagine there's an SOP for a Dremel tool. And so there's going to be this judgment exercised along the way about not just all of the things that they're, sufficient agreement and all that stuff, but how do I go about the process of making the things to see if they agree? Yeah, I just don't get how that went. Maybe it's because you got to wait for 702 anyway. And if the point was to just kind of drop these hints about the unreliability of toolmark stuff and the conclusions, the limitations of the conclusions and so forth, but just he never even applied it to the Dremel. Like, I can see how it's easier to make this point with the firearms because it is standard and there's going to be a lot of things he can rely on, the studies and the standards and the stuff like that. And you're not going to have that for the Dremel. She's not going to have her handy dandy little Dremel tool bit model to show you how this works. So I guess it might be harder to kind of make some of those bigger points, but that was very, very strange to me. I have to think we're going to see this in the quote unquote 702, they're going to challenge this. But again, even with that, I think the best they can really hope for is she's going to say it's consistent. Dremel tool is consistent. So, okay, it's not like real definitive, but it's just yet another brick in the wall of the inferences, the connections, the things that are starting to build, and it becomes a point with your circumstantial case, the inferences that you can draw from circumstantial evidence, that there's a point where it's coincidence and there's a point where you're just not willing to accept that it's coincidence anymore. That's not a real crystal clear line. It depends on your jury, but everyone's got one. Michigan Farm Boy, if it was a CNC and ran the same pattern consistently, maybe see the tool wear, but it's handwriting analysis with a tool added. No way this is good. Yeah, that's a very good point. I don't even know how much I have to think the handwriting is not in and of itself the factor. Like, we're not trying to compare the handwriting, so to speak, on the two cartridge casings. That it's literally just looking at the engraved part and looking for those micro striations and stuff like that. The width of the thing but just how are you going to get to individualized? I was able to identify this. Yes, I call bullshit. I'm with you on this. I look forward to the 702. That will be interesting. Kyle Wilbur, 4318. Can you recognize that your lawyer mind not open I think you mean not open to other factors. Also love your work. I'm not trying to be argumentative. I love a good debate and a good disagreement even. I don't take it personally. I enjoy these conversations. What am I not being open-minded about? What am I not being open-minded about? The problem, I think, with so many of these theories that I see, there's nothing like wrong with them in a vacuum. Again, taken in isolation, glass in the SUV might be an issue. But it has to account for all this. This is my evidence list, right? All the stuff against Tyler Robinson. This is also part of the universe that exists to explain what happened. And so all of this needs to be explained. If the glass is important, great, I'm all ears. But if your explanation doesn't account for how all of this also came about, I'm probably not going to consider it a very good explanation because it is an incomplete explanatory theory. Maybe that's a lawyer mind. I don't know. I just think it's a logical mind. But, you know, if there's a specific thing I should be more open to, I'm happy to entertain it. I certainly consider myself pretty open-minded. I form opinions, but I don't think for the most part, most of my opinions are all that fixed. I stay pretty flexible. I wait to see. I've said, I think from the day one, I want to hear what the defense has to say. I'm not going to make up my mind, guilty, not guilty, until I hear what the defense has to say. I want to give them a fair shake. Because, yeah, there could be stuff there that I don't know. So I'm not going to be too firm in my opinion, but it doesn't mean that I can't have opinion based on what I see so far. Definitely leaning toward this ain't looking good for Tyler Robinson. It's because of all this. So I think maybe that's the disconnect. I really feel like that's the disconnect between the, you know, quote unquote conspiracy, you know, stuff and the court focus, the Fed slop. You know, if we were just going to go ahead and use our thought terminating cliches on both sides. That's the difference, is that I think that's the disconnect, is that I feel like this pretty well accounts for most of those other issues. Glass in the SUV, I don't see why it matters if Charlie Kirk was killed by a gunshot wound to the neck by a .30 caliber bullet. And that's what the evidence seems to be. And so I think we're just, nobody can offer like a universal, unified theory of the whole world, the whole event that includes everything that I guess people are talking about and interested in. You know, every single plane that landed in the airport, thoughts in people's minds. I'd say that's just, you know, from my perspective anyway, this is the problem I have with most of the theories I see. Fine in isolation. Sure, great. Notice that there's some glass in the SUV. Wonder if it's significant. But in terms of like criminal liability and what's happening in this case, Charlie was killed by a gunshot wound to the neck. It doesn't seem that anybody is really disputing that. So I don't know why it matters. And the only way this is see, and this is where it gets challenging, because the only way that it seems to matter is that people hypothesize stuff that, from my perspective, is very accusatory and very unfair. I'm not inclined to do that. I'm not inclined to accuse people of things just because I imagine stuff that could be possible. It doesn't violate the laws of physics that people did X, Y, and Z horrible things. But if there's not evidence that that is in fact what happened, I am not going to accuse them of that. Other people are more comfortable with that. And that's a big part, I think, of the disconnect too. And that's why it's become polarized and emotional, and people are not happy with each other. I hope that clarifies kind of my perspective on all this and where I'm coming from. If I'm not open-minded, like I said, I'm happy to consider anything. But I just think it would help to see that this all needs to be explained. And by explained, I don't just mean call it Fed slop, because that is a thought-terminating cliche. That is not an explanation. I need to provide, I need a theory. I need a unified theory, and I need to see some evidence that tells me that that's true, not merely, well, it could be. So far, I haven't really even heard a it could be that accounts for all of this. But we got a long ways to go before this case is over. We still got a lot of ground to get through before this case is over. And so, yeah, there may be more. I mean, like I said, I'm waiting to see how this whole bullet fragment thing plays out. Because that is significant. If that's the case. Bullet fragments have literally gone missing and are unaccounted for. That's alarming. That's a problem. Definitely not very helpful. Emil C. Look, I'm sorry. Trying to make light. You good. You're good too, Emil. I don't hold things against people. I have no problem with anything you've said. I've appreciated it. I think I appreciate the path that you're on and the motivation that you have for it. I think it's a inspirational thing that we all share. We should all try to be better. You know, whatever path that involves and whatever it looks like. Michigan Farm Boy, off topic, but thoughts about courts only giving lip service, limited remedies to Brady Giglio violations other than Rust case. Yeah, what's the only other one I can think of? Senator Stevens. You know, I guess if you're like a senator, then then you can get some. If you're a movie star or a senator, you can get a meaningful remedy for a Brady violation. Brady is the way that so much of the law develops. I've mentioned this before, is that the court will announce some grand principle, particularly in the criminal law, some grand principle. I'll give you an example. When we got Crawford versus Washington from Scalia, I forget what year it was, 2005-ish, something like that. We get Crawford versus Washington. It's revolutionary because you know, the right to cross-examine hasn't meant anything for a long time, because they've created all these exceptions. Well, as long as it's reliable, then it's okay. And so then, you know, courts find all kinds of ways to find all kinds of bullshit reliable. So Crawford comes down and it creates this black line rule. No, like, right to confront means something. And so if you are effectively a testimonial witness, then you have to be cross-examined, period, full stop. This was a big deal, right? Massive change, very, very favorable to criminal defendants. And then what happens is you spend the next several decades ratcheting it back. Right? Sounds great to have a Fourth Amendment. It sounds great to have a Fourth Amendment. You have a right to be free from unreasonable searches and seizures. But that means we're going to spend a lot of decades defining pretty much anything police ever want to do as reasonable. So all of these exceptions, the reasonable expectation of privacy, that's the one that's really on the in the sights right now with the digital era. And again, Chatry, the third party doctrine, this exception to the warrant requirement that, well, if some third party has your information, you're giving it up to them, then you don't have any expectation of privacy in that. But every single time you touch this thing, you're sending off information to everywhere. I mean, that is your whole life. It is all being held by third parties. Is that really what we mean? No expectation of privacy and all that data? Ugh, that's frightening. That's frightening. So, I mean, Brady is the same way, right? Brady's the same way. It's this great principle, but then just as time goes on, it gets narrowed. And it gets narrowed, and it gets harder and harder to really kind of get anything meaningful out of it. And then people also kind of figure out how to game it. I had a case with a Brady issue. I thought a quite a significant Brady issue, and it came out at trial. Came out during the trial. This piece of information that law enforcement had withheld from my client, from his trial attorney, and very significant because it went to the state's whole theory of this case, and it was a jail killing, beat down. Guy basically got beat to death in jail, and it was alleged to be gang related. Anyway, they had information about this guy's status, gang status, and everything like that was directly contradictory to their theory. Comes out in trial. So no chance to like develop this, follow this up, corroborate this, nothing. You're in the middle of trial. Well, guess why it's not prejudicial. Even if it was a Brady violation, which they'll do that. Even if they needed to turn this over, it's not prejudicial. Why? Because they got it in trial. So the jury got to hear it. None of this appreciation of like, but I lost the opportunity to be able to do anything with that, to convince the jury why this should matter. What, to corroborate it, to show them like, we're not making this shit up. So a lot of gaming going on with it, stuff like that. Tightening up what even counts as exculpatory. That's always a fun one. Arguing with prosecutors over what's exculpatory or not. Oh, you want to spend some time being aggravated? Prosecutors who have decided what's important in your case and what isn't. And people wonder why I wanted to take a little sabbatical, little step away from full-time public defense. Yeah, I mean, unfortunately, I think this is kind of consistent with how the court's protection of our rights works across a variety of different areas. Matthew McClellan, big light bulb to say our it could be's shouldn't blame new people, in my opinion. Many thanks for that. Well, I'm glad you helped that. I'm glad that was helpful. Everybody's going to have a different tolerance for levying accusations against other. I've wondered for a long time, this has been on my mind, because a lot of you longtime people, I'm really into like personality, stuff like that, characteristics, this like deep embedded stuff that plays a role in who we are is kind of beyond our level of control and seems to emerge really early in child. Like a lot of personality characteristics, they like come out really early. Not real clear, the whole environment and nature nurture role kind of thing and stuff like that. Very interested in all these issues, but anyway, the personality characteristics, like specifically the Myers-Briggs, I've often wondered, I consider myself the last one, J or P, judging or perceiving. I consider myself a P. And that's minor. That's the minority. Most people are J's. And I feel like that plays a role in it. If you like to and are inclined to pass judgment, to judge things, that includes other people and your fellow citizens. And I can see a real spectrum between people who are like kind of want to give everybody the benefit of the doubt. Now, I'm not Melanie Wilkes over here, okay? But let's use that as our as our extreme end. The non-judgmental. You guys know Melanie Wilkes, right? From Gone with the Wind. She's like our extreme, doesn't judge people. I'm closer to the middle. Like I will, of course. It just takes me a little more to get there. And I want to be sure. I'm very conscious of like if you're accused of something that feels bad, and so I have that empathy for the person that I'm accusing, even if like they are, even if they are a shitbird and they did awful things. And I'm still going to feel bad for them as a human. This is why probably why I was good at criminal defense. And then you have people that are far more comfortable with it. You have people that like to gossip a lot. People that like to gossip. I'm not into gossip so much. I don't know. But a lot of people are. A lot of people really like to gossip, know about other people's business. Oh my God, can you believe? Can you believe? And then you just go to the far extreme where you have, people that just really enjoy the moral high ground, pointing the finger at people. It like feeds them. It makes them feel good. It's like necessary for their sense of self, their ego. So I've always kind of wondered if that's related to the personality factors, but that's the spectrum that I see. I put myself far, pretty far on this end of I don't like to judge people. And so when I see it happening, I don't like it because I feel bad for the person that's being accused. Other people aren't going to share that. They're going to find it much easier to accuse. And so I think that's a big piece of this dynamic that we're seeing. Amy LC, bro, I've been working and listening since 8 a.m. Bro, I've been online and talking since 7:45. Well, not straight through. No, man, not today. Not straight through. I'm just giving you a hard time. Hey, thanks for still being here. You're burning the midnight oil. I hope you're getting some good OT out of all this. Amy LC. Okay, so do you think if they had that Batman shit from the movies back in the day, wait, let me read this again. So do you think they had that Batman shit from the movies back in the day from Joker? Sorry if you got hurt. I'm sorry, man. I just don't know where you're going with this one. I don't know where you're going with this one. Which Batman? Which Batman? I like Dark Knight. I know Dark Knight is like not anybody's. It's not like the critics' favorite or anything like that. But I personally like Dark Knight. But I'm not probably going to admit publicly in front of my husband how much that has to do with Christian Bale. So. Michigan Farmoy, didn't mean to re-traumatize you. So just don't elect prior prosecutors as judges. Like you said, go watch local court and vote accordingly. That's the best way to do it. And I won't say don't elect prior prosecutors as judges either, because as we know, prior public defenders can make some really awful judges too. Bev's a prior public defender. It didn't make her a good judge. We had this guy over here. I've told this story many times. You can look him up. Scott Galina, Gallina. Google Scott Galina. He's the Asotin County judge, which is southeast corner of Washington, Clarkston, Washington. He was a former contract public defender. We're like all contract public defenders over in the rural side of the state, because we don't have like central. So he did other things, you know. He's not just a public defender, but he did public defense. He wasn't a prosecutor anyway. Anyway, he got elected judge, and that didn't go well. That didn't go well for reasons, criminal reasons that I can't say without getting the stream taken down. Things he was doing in the courthouse with the courthouse staff against their will. Yeah, that didn't work out real well at all. It would be nice if there was just an easy formula like that, but unfortunately there just isn't. And there's a lot of politics in the judges, you know, as you might imagine. I don't just mean you know, appointed stuff and things like that, but you know, who gets the support, who gets the endorsements. If you get your law enforcement endorsements and things like that, you're probably going to be more likely to get the position on the bench. So there's a whole, you know, game that goes into it too. It's, I don't know. I'm so black pilled on politics at this point that I kind of lump it all in the, you know, the paradox, the paradox that Socrates talked about in the Republic, about, you know, those who are most suited to positions of power are least likely to seek it out, and those who are most inclined to seek it out are the last ones you should want to have it. But that's the world we live in. Two Truth for Liberty. Expectation of privacy. Gorsuch concurrence. 25 to 112. I haven't gone back and like mapped out the whole opinion again for a while. I get a little fatigue with the Supreme Court decisions and like trying to track all of the it's like tributaries, you know, trying to follow US Supreme Court stuff. The Chatry was a big deal, mainly for me, because here in Washington, we have our own independent constitutional jurisprudence. We have Article 1, Section 7. Article 1, Section 7 is far more protective than the U.S. Constitution. So I really don't have to keep up on the Fourth Amendment for the most part, most of the time, because all I have to do is just do enough to make sure I'm preserving it for federal habeas. It's pretty much it. But it's not where I expect my cases to the win or loss to turn on. But Chatry was a big deal because, you know, my court hasn't ruled on geofence warrants, and so it's likely to be really influential. But this is a big issue everywhere. Just because Washington doesn't do the reasonable expectation of privacy, we have private affairs, which are absolute. But we still have at least a limited third-party doctrine, because it's not private if it's with a third party. That's the basic idea. So it's not even your stuff, you know. It's like the phone's records, it's the bank's records. Now it's going to be Google's records, and that's a scary place to be, I think. So it is going to be interesting to see if there's a you know, shift in thinking on that in the coming years. Michigan Farm Boy, really appreciate you, Jeff Mods, doing all the coverage and the commentary. Enjoy the weekend night. Thanks so much for spending your evening with us here. Thanks for your support. Thanks for your good conversation. It's been a week. You know, it's been a week. There's been a lot to process. There's going to continue to be a lot to process. But yeah, I appreciate everybody, all the contributions you have. I wish I was better at like being able to read while I'm talking so that I could follow more of the regular chats when it's just like commentary. It's one of my favorite things about watching the trial or watching the hearing and stuff is because I can if I don't have to talk, I'm just watching what's happening. I got to take my notes, but I can still, I can peek in on the chat, keep track of things from time to time. And I really enjoy that because I really do enjoy the conversations we have here. Yeah, I think it's a good time to call it a night. It has been a long week. I don't even know what's coming up this next week or like next or anything. So lots of times after we wrap up something like this, I like to advise people, here's what's coming next. Here's what you can look forward to. If you're interested in this, I'll be on it. But I don't have any of that in my mind right now. I'm like, it's been so all Tyler Robinson all week. Really not even sure what's going on next week, but I'll get oriented over the weekend. I'll figure out what's going on and usually find some way to get the word out if I'm going to be doing something. But otherwise, yeah, now we wait. Now we wait. We'll get some briefs to look at, see what unfolds as far as arguments about our cameras on September the 1st. Just putting it out there in the universe, it would be real nice if somebody mentioned that the judge never found any kind of willfulness. Nothing. Maybe isn't so appropriate to sanction. And even if it were, maybe it would be better for the sanction to hit the people that are causing the problem and not those of us at home that are just trying to be good citizens and learn what we can about a court process. Really would appreciate that. Just putting it out there in the universe just in case. Oh, you know what? I know what I got to finally get to. I got to finally get to Jim Martin's sentencing for sure. I will that'll be a good one. But yeah, as far as like upcoming stuff, I'm going to have to dig in and see what's going on and kind of figure out where I'm at. I know I have to go down to get Malice's exhibits in a couple weeks here, but other than that, completely disoriented. So hey, for that, thanks for a great week. It's been a whirlwind. It's been fun. I've really enjoyed it. I hope you guys have enjoyed it. I hope you found it informative. Thank you all the mods. Thank you so much. I still think about doing a deep dive on the DNA stuff in this case because I know I talked about it, but I feel like there's so much to say about that and it's such an interesting issue. Maybe once I get the DNA evidence organized, I'll sit down and we can go through that and kind of use that as a baseline to talk about some of this stuff. Yeah, I always got lots of ideas, so it's kind of just a matter of time and also a little bit motivation. It is the time of year where I really enjoy being outside more than I like sitting at a desk, even with great company. It's nothing personal, guys. So with that, we're going to call it a night. Thank you all. Thank you, mods. Thank you, Kyle Wilbur, for the positive. I enjoyed that disagreement. I mean, I hope I took it not personal at all. I don't take disagreement personally. I thought it was a great conversation. I thought you were respectful. I thought I was respectful. That's like how things should be when people disagree about stuff. So thank you for that. I'm very grateful that we got to have that conversation. I hope that it helped us get a little closer and see a little more eye to eye. And for anybody watching, maybe it gave them new ideas too. I can be hopeful. I can be hopeful. Enjoy your night, everybody. Friday night. Sleep in if you feel like it. And have a wonderful weekend. Enjoy your summers. Take care of yourself. Hug your loved ones. That's probably a good thing after a week like this. You know, a lot of pain in criminal cases, and so it's good to take some time to just remember the stuff that matters. So let that guide us this weekend. I plan for that to be in my heart as we move forward. Have a wonderful evening, everybody, and I will see you next time.